All right, councilors, let's go ahead and go on the record, please. All right, good morning. We're back on the record in the matter of those who are in indictment 22 SC 183572. Let me go ahead and just take roll. All right, let's just see who's here for the time being. Khalif Adams.
Good morning, Your Honor. Jeffery.
Good morning, madam. Okay, all right. Durante Beebe.
Good morning, Your Honor.
All right, good morning again. Okay, Damone Blaylock.
Your Honor, this Attorney Hill, he's in a probation revocation hearing in Gwinnett County. As soon as it's over, he's going to come right down.
Say again. Do you know if he's waived his client's presence? Does he give you that particular talk with waived his presence?
No, Your Honor, he hasn't. No.
Do you know if he told you if he filed a conflict letter?
I can find out, Your Honor.
I tell him he needs to be here. He'd be here. And if he didn't file a conflict letter, that's going to be a problem. All right. Jeffrey Williams, good morning, sir. Good morning, Mr. Adams.
Good morning, Jeff. Good morning.
All right.
And for them,
All right, Cordarius Dorsey.
Good morning. Also,
Good morning, sir. All right. Christian Eppinger. Good morning, sir. All right. Mr. Menendez, good morning. Good morning, Mr. Farley. All right, Mr. Fleetwood. Where's Mr. Fleetwood? Just raise your hand, sir, if you're here.
President in the back, Judge.
Oh, where?
President in the back.
All right, thank you, madam. Mr. Garlington is, we are awaiting him. I know where he is at this point in time. All right, Quintavious Greer.
Good morning, Your Honor.
Good morning, Ms. Mormon. Good morning, madam.
Mike Russ for Mr. Greer as well.
Good morning. All right, Marquavius Huey.
Good morning, Judge. Matthew Sr. and Jr. here.
Good morning, gentlemen. All right. All right, DeMonte Kendrick.
Good morning, Your Honor. Doug Weinstein.
Good morning, sir. All right. All right, Demise McMullen. Thank you, sir. Tanquarius Mender.
Good morning, Your Honor. Nicole Fagan on behalf of Mr. Mender.
Good morning, Ms. Fagan. And Ms. Fagan, I'd note for the record, you were also present yesterday. What time did you come in yesterday?
Right on time.
Right on time. There you go. So we accounted for you for both days. You get a check mark. That's wonderful. All right. Jaden Myrick. Ms. Bernard, good morning.
Good morning, Judge.
All right, Cormerivius Nichols.
Good morning, Judge.
Good morning, Mr. Harvey.
I was early both days going get some benefit for that?
Yeah, Mr. Bott said he'll give you, you know, maybe some bagels.
I've got help with eating. It's Hanukkah, we are celebrating. Nicole Westmoreland and Lamar Gardner is also with us.
All right, thank you, sir. Good morning, councils.
Earlier today too.
I saw. Listen, I see everybody. You know. Thank you, sir. All right, Rodeus Ryan, Mr. Williams.
Ambulance, Mr. Ryan.
All right. Good morning. Antonio Sledge. Where's Mr. Sledge?
Judge,
Yes, sir.
Mr. Wright is his attorney. He didn't need him for this morning.
That's right. Okay, you were correct about that. Trintavia Stevens. Ms. Gladden, good morning, madam. All right, good morning again. All right. Mr. Garlington, good morning, sir. All right. All right. Good morning, Mr. Botson, Mr. Short, and good morning, Mr. Stillwell. Okay. All right. Yeah, I know. You pay. I understand. That's right. Thank you. All right. And Antonio Sumlin. Mr. Hoover, good morning, sir. All right, couple of administrative announcements. From yesterday evening, I've talked to Mr. Kearns, my staff attorney, and we will have the compendium questionnaire emailed out to you by close of business today or shortly thereafter, so that we can have a discussion about those questions Thursday morning. So that's the first thing. Second thing, I would just politely remind everybody. I asked everybody to kind of be here at 9 o'clock. I start by 9:30. We can't start till everybody gets here, so it's as much as you can. Please go ahead and get here timely. And if you run into any problems, as many of you have done, please just contact my chambers. But try as much as you can to be on time so we can go ahead and get started, as we've got a fair amount of business each day which we'll try and accomplish. All right. Those are the only two administrative announcements I have for this morning. As I understand it, Ms. Rosenwasser, you have Mr. Pineda available, is that correct?
Yes, Your Honor, we have Mr. Pineda and Investigator Hall. We have Mr. Pineda first.
Let's call Mr. Pineda first, please. Thank you. All right. Walter Pineda. Mr. Pineda, good morning, sir.
Good morning, sir.
If you would please approach the witness stand. Once you get there, if you would be so kind to turn and face Deputy Talton to be sworn as a witness, please.
Raise your right hand for me. Be sworn in affirmative testimony I give the court the truth, the whole truth, and nothing but the truth, so help you.
I do.
You want to take a seat? State and spell your first and last name.
My name is Walter Pineda. Spells WLTERPINEDA.
Sir, you can sit down, please. Thank you.
Good morning, Mr. Pineda.
Good morning.
Mr. Pineda, where are you employed, sir?
I'm self-employed and I work for a company called Marathon Photo.
Okay. And just so everyone can hear you in the back, I'm going to need you to lean forward and speak into the mic a little bit, okay?
Okay.
Okay. And how long have you been employed in that position?
I've been doing video enhancements for almost 30 years.
Okay. And what were you, how were you employed previously?
I was employed by a company called Pinkerton. I went there until the company closed down. And I went independently.
And can you tell us a little bit about your educational background?
I got a degree in professional photography and design.
Okay. In your current position, how did you become involved in that line of work?
The company that I was working for, we were taking care of financial institutions, taking care of people that were doing forgeries and bank robberies. So I was able to be trained by the company to be able to get the images that they needed for the person that committed the crime.
And do you have any relevant training or?
The company trained me at the time.
Okay.
Because back then it was film.
Sure. How do
And
you
then-
see it? I'm sorry.
Back then it was film. Then it became video or VHS, CDs, and then hard drives.
Mr. Pineda, how do you stay up to date on your training?
I follow the training on the experience that I have to do the same things on new cases.
Do you have any specific, like, continuing courses that you
Yes,
take?
I do. I became a bilingual interpreter in legal, medical, and educational interpretation.
What kind of certifications have you obtained?
That will be the legal and the medical interpretation certification at UGA.
Approximately how many, video enhancements have you performed over the course of your career?
I would say thousands.
Your Honor, at this time, I move to admit State's proposed Exhibit 10. May I approach the witness?
All right, has that exhibit already been shown to defense counsel?
Yes, it's been served in discovery.
Providing discovery?
Yes, Judge.
All right, you may approach the witness.
Mr. Pineda, do you recognize this document?
I do.
What is it?
My resume?
Has there been any alterations or changes to that document?
No, sir.
Okay. Your Honor, I move to admit State's proposed Exhibit 10, previously served to defense counsel. Acceptance.
Any objection to States 10? Purpose of the motion. All right, States 10 is admitted.
Mr. Pineda, have you been qualified as an expert before?
I do.
What states?
Georgia,
Okay. And what courts?
state,
About how many times would you say?
over 50 times.
Okay. Can you describe for the court the method video enhancements are performed?
Yes, I do. When I get a video, I check the image, the quality of the video. When I get to find the image that I'm interested in, I will divide the image or the screen in 4 sections, and I will get 1/4 of that section to follow up on the particular image or interest of the image to enhance the video.
Okay. What kind of results can be expected from, enhancing video evidence?
The result could be a better view of the evidence given by the prosecution.
Is this type of video enhancement, like you described, just described for the court, have other law and agencies used this type of service?
Yes, they have.
Just prosecution?
Prosecution, defense attorneys, police departments, GVI, and FBI.
Okay. And as far as you know, is it generally accepted?
Yes, it is.
Okay. Are there any kind of standards or control, how video enhancements are performed?
You have to follow a protocol, meaning when you divide the images in 4 sections, that 4 will have to be get the first image, and if it's too small, then you go to a bigger image, and if he wants it to be bigger, then you go to a bigger image.
Okay. And that standard that you just described for the court, did you follow those procedures?
Yes, I did.
Okay. What did you enhance in this case?
In this particular case, I enhanced 2 videotapes or 2 videos, one from a parking lot area by a car driving by and a gas station.
And you did use that standard for the enhancements in this case?
Yes, I did.
Okay. Your Honor, at this time, we would ask that that the court qualify Mr. Pineda in forensic video analysis based on his experience, his background, training, and the fact that this is well established.
The forensic video analysis?
Yes.
Okay, all right. Anybody wish to voir dire the witness?
Yes, I do.
All right, go ahead, Mr. Adams.
Thank you. On behalf of Mr. Williams. Mr. Pineda, good morning, sir.
Good morning, sir.
You can hear me okay?
Yes, I do.
All right. I want to ask you a few questions, please, about the work that you've done and what you just testified to. And if you don't understand the question, please let me know and I'll be happy to rephrase, okay?
I will.
You indicated that you've been qualified as an expert previously
Yes, I have.
in the state courts here in Georgia.
Yes, sir.
And you've been qualified in what field or in what particular category specifically?
Video analysis and video enhancements.
Now, you stated earlier, I want to ask you some questions about the protocol that you referenced. The state asked you whether or not there is a particular protocol that you follow in regards to video enhancement. Could you describe for us what that protocol actually is, please?
The protocol is to follow up the section in which I'm involved to enhance, meaning I have to divide the screen in 4 sections. That 1/4 of the sections, I follow up the same size, the images in which are being involved on the video analysis.
All right. So that's a description apparently of what you actually do in terms of video enhancement.
Yes, it is.
But in terms of the protocol, are those protocols recorded anywhere? They're written protocols that govern exactly how you enhance a
The
video.
protocol is involved in the images given to the prosecution.
Okay.
Every detail is given to them in every folder, tells you a description of what it was done to that particular image.
Okay. So would I be correct in that what you're saying is that when you forward what you consider to be the enhanced video to the prosecution, you have instructions or you're telling them exactly what you did to enhance that video?
I did not write anything to that matter. I just let them see and see for themselves for what I have done.
But in terms of when I say protocol, are there any written protocol from any agencies, any organizations that talks about the best practices for video enhancement that you
No.
are aware of?
No,
There are none?
not that I'm aware of.
Okay. Are you aware of whether there are any publications that make reference to the mechanism that you use, the protocols that you use, any publications that you would look to in regards to video
No.
enhancement? None?
None.
You referenced earlier in your testimony that the video enhancement is used by other agencies. Are you familiar with whatever protocols are used by those agencies in video enhancement?
They don't use any protocols for me to use, no.
Okay. You responded to one of the prosecutor's questions earlier. He asked you whether or not you know if the standard of video enhancement or the practice of video enhancement that you utilize, whether or not it is, quote, generally accepted. And you said it is.
Yes, it is.
Do you know by what agencies or what entities that protocol is generally accepted by?
It has been accepted in the Cobb County, Fulton County, and Gwinnett County.
Okay. And when you're responding to it being accepted, are you talking about it has been used in those counties? Video enhancements has been used in those counties? Is that what you mean?
Yes.
Okay. All right. Thank you, sir. I have no further questions for this witness.
Anybody else? Go ahead. Mr. Weinstein, you can go third. All right.
Thank you, Your Honor. Sudi Chad, Jimenez, on behalf of Mr. Dorsey. Good morning, sir. How are you?
Good morning, sir.
Now, what was your name again?
Walter Pineda.
Mr. Pineda, how are you?
Fine.
All right, so we spoke a little bit about the way that you developed your expertise, what you claim to be your expertise, and you said you used to enhance tape back in the day, right?
Film.
Film. And then film developed into VHS, is that right? And then CDs, is that right?
Correct.
And now they're hard drives.
Correct.
Is that correct? So now, is it fair to say that technology has changed drastically?
It has.
Have you received any training as it comes to the new technology that is used nowadays in the video recording?
I have not.
Okay.
But the last time that I worked for Pinkerton, we already were using hard drives.
But you haven't been trained formally by any agency or any education from any school?
They don't have anything available for that.
All right. Now, when the state asked you, did you receive any further training, your response was that you have gotten training as a bilingual interpreter and as a medical interpretation. Is that right?
Correct.
All right. And those things have absolutely nothing to do with video enhancement. Is that right?
Yes, that's right.
You don't need to speak Spanish to be able to enhance a video.
Correct.
Now, you describe the way that you do it, but you have not told us if that is the way that everybody else does it. Is that right?
I don't know how everybody else does it, but the way I do it, that's the way I've been doing it for years.
Okay. And do you have a bachelor's degree?
No, sir, I don't.
Do you have any type of education with IT?
I don't have.
Okay. Do you have an associate's degree?
No, I don't.
You have a high school degree?
I have a high school. Yes, I have a high school degree and I have a diploma on professional photography and design.
All right. Where did you get your diploma on professional photography?
Southeastern Center for the Photographic Arts.
And when did you get that?
I got that in 1987.
1987. Has the technology that was used in 1987 changed drastically to the technology used, say, from 2010 to 2022?
I believe so.
Have you been trained in that new technology by any formal education agency?
No, I have not.
Now, when you say that you have testified over 50 times, is that right?
More than 50 times, yes, sir.
And when was the last time that you testified?
I testified over probably about 6 months ago in DeKalb County.
DeKalb County, okay. Now, you also said that you have testified for the defense sometimes, is that right?
Yes, I have.
How many times out of those 50 plus times?
I would say more than 10 times.
About 10 times, okay. Now, when you enhance these videos, you describe as you break it up into 4 sections, is that right?
No, I break it up into 4 sections and use only one section.
Okay, and when you break it up into that 4 sections and use that one section, what do you do with that one section?
That one section follow up on the images involved on that particular event. So I get all the images involved to see if the person is going by. I capture every single event of the person going in front of the camera.
But other than freeze framing the video, what do you actually do? What is the process to, as you say, enhance these images?
All I do is get closer, and if the image is too noisy, you reduce the noise out.
Is that something that I could do if I had the right software to get it done?
You can do it if it's up to you, yes.
So any layperson that has the right software could just go ahead and do that? If
they will have the experience, they want to do it, it's up to them.
But so you don't have to have a degree or any level of expertise to actually do that?
Correct.
And is it fair to say that sometimes some careers just with technology advancement just become obsolete?
Not this particular one. I mean, I've been doing it for 30 years.
Then how come are you moonlighting as an interpreter as well?
No.
Okay, so how come you haven't gotten any further training as to the technology?
Because people are not using video technology as much as they used to do it in the past.
Okay. Has anybody ever reviewed your work? Has there ever been any peer review of the work that you do?
I'm not aware of. I mean, the only thing is give the evidence to the prosecution or to defense or to the police department, and they're satisfied with it, and they are.
What is the name of the software that you use?
I use a software called Photoshop.
Photoshop, that's the one I can get on the Apple Store?
It's up to you, whatever you want to do it.
Thank you, sir. No further questions.
Mr. Pineda, Mr. Pineda,
Yes, sir.
over here. How many video enhancements have you done over the course of 30 years? Just ballpark.
I would say over 500.
Over 500? Okay, all right. Next.
Doug Weinstein for Mr. Kendrick. Good morning, sir.
Good morning, sir.
You were saying that you're not aware of any organizations that certify video enhancement technicians. Is that correct?
I don't.
Are you familiar with the International Association of Identification?
No, sir.
Are you aware that they have certifications?
I sustain the objection.
Okay.
Remember, it's knowledge, skill, experience, training, or education, okay?
Are you certified by them as a forensic video technician?
No.
Are you certified by them for forensic photography?
No.
Are you familiar with the paper by the Scientific Working Group on Imaging Technology that lays out guidelines for following imaging
No.
techniques? So according to their guidelines, you're supposed to keep a documented record of the techniques that you use. Do you keep a documented record of what you do?
I don't.
It also states that you should have peer review of your work. Is there peer review of your work?
I don't know. I don't know who has reviewed it.
I'm sorry, could you say that again?
I don't know who has reviewed it. No, I don't.
Are there others in your company that review your work?
No. I work independently, sir.
The guidelines also state that there should be annual training. Do you participate in any annual training?
I have not.
Your Honor, object to their last question. Witness specified he's not familiar with the guidelines.
I asked if he participated in annual training.
Training, that's different. I'll overrule the objection.
Have you undergone any competency testing?
No.
The guidelines also specify that there should be proficiency testing. Have you had any proficiency testing?
No.
The guidelines also state that there should be standard operating procedures for image enhancement. Do you have a set of standard operating procedures that you follow?
I do.
And what are those standard operating procedures?
Like I told you before, I follow up the way that I always do it in every single enhanced video that I work in.
And are those standard operating procedures written down somewhere?
No, sir.
So
Something I learned through the years.
Your technique for image processing involves breaking the image up into 4, can I say quadrants? Is that fair?
Correct.
When you analyze those quadrants, do you do that in the spatial domain or the frequency domain?
The frequency domain means the frame that I obtain out, in which is highlighted. So I follow that by every single image that I'm working in.
I'm not sure that you followed the question. Sir, do you know what frequency domain processing is?
Not specifically, no. But
Do you know what, I'm sorry.
Go ahead.
No, finish your answer, please.
No, go ahead.
Sir, do you know what spatial domain processing is?
The spatial is the space, I think, is the space in which you are involved according to the images on the monitor.
Do you know the circumstances where you should use spatial domain processing?
No, I don't.
Do you know the circumstances where you should use frequency domain processing?
No, I don't.
When you're seeking information from the image, do you know when it's appropriate to use spatial domain processing versus frequency domain processing?
I'm not familiar with that.
I sustain the objection.
And the last question, sir, is your particular processing technique. Do you have any publications?
No, sir.
Thank you. I have no further questions.
Anybody else?
I do, Judge.
Couple means two. Don't lie to me, okay? So, go ahead.
It's colloquialism, Your Honor. Now, I just had a few questions. So, do you ever compare one of your enhanced videos to a video of the same thing but of higher quality to see if your enhancement actually made it look enhanced?
If you're telling me about a video from 10 years ago and a video right now for 4K, you will see the difference. From 10 years ago, it's very grainy. From today's, it's very clear. I can see your freckles. I can see your eyelashes.
Okay, it's true, though. I don't have freckles, though, do I?
Oh,
Outstanding.
Okay, but what I was really asking you is, have you ever taken maybe a HD camera and videotaped something, and then taken a non-HD video camera and videotaped the same thing, and then supposedly enhanced the non-HD one so we can compare the two and see if your work actually makes any difference at all?
yes, I have.
Okay, and how many times have you done that?
That's 'cause, like I said one time, 10 years ago, I used VHS cameras. Today, I have myself a new camcorder, 4K, so you can see the difference. I did not take the same thing, but when you do the close-ups or the enhancements of it, you can see the difference and the details on the image.
Okay, and did you record that anywhere, the accuracy
No,
of
I
that?
didn't record it.
And that was 10 years ago?
No, I did the video on 4K not too long ago and the VHS years ago.
Okay, and then you said you use Photoshop to enhance the images?
Yes, sir.
And it's also true that Photoshop can be used to alter images?
Yes, they can be used, but I haven't.
Okay, and how are we supposed to tell, besides taking your word for it, that you haven't altered any images?
You tell me which one I have done, and then I'll respond to it.
Okay, so just your responses.
If you have something that I've done that is being altered by me, you let me know.
Okay, and then once we let you know, what's going to happen next?
I don't know.
Basis. Relevance.
Your Honor, it goes to his direct previous question.
As to in terms of what? What previous
Like
question?
how we're, the general question still hasn't been answered, but how are we going to know whether one of his work product items has been altered in
Is
Photoshop?
that an issue in this case?
Yeah.
You think that he's altered one of the documents or altered it?
No, Your Honor, credibility is always that issue. And
That's
so,
weight. That doesn't go to the things that I'm the gatekeeper, remember? So part of that is, do you have something that would indicate to me that he should be disqualified because he's altered something? I don't think there's been anything in terms of foundation.
Your Honor, my point would be that if there isn't a way to know whether he's altered it or not, that goes to the weight and the credibility.
Well, that's a determination for the jury to make. But I'll make it, of course, I'll make an initial threshold under Daubert. But the relevancy issue is kind of waning, so move on.
Okay. So apart from asking you and you answering, we don't have any way to know whether or not you've altered images in Photoshop.
It's up to the person to decide, not mine.
Okay. And what person do you mean?
It could be you, it could be the jury. I don't know.
Okay. All right. Thank you. I don't have any more questions, Your Honor.
Anybody else? Any other defense attorneys? Okay, all right.
Your Honor, I would want to also move to qualify him as an expert in bilingual language interpretation. You say that he's trained in that.
That's not what you're here for. That's not what he's here for.
Well, I'm trying to make him here for that for a trial for my own reasons.
Well, you need to subpoena him and pay him. Okay? And then maybe he'll show up. But don't try and circumvent the process. There's a way to subpoena witnesses and everything else. And you want to qualify him as a bilingual. If you have a separate need and employment, then I'll let you do that off kind of at your discretion and your leisure, okay? But that's not the time to do it now.
Okay, Judge, and for the record, it was just that based on his answers to the state's questions.
I know, but that just fills out what he's been doing the past 30 years, okay? In terms of what he has done. additional education he's gotten. You've already kind of examined him about that. It has nothing to do with video enhancement. It's just another skill set that he has. Okay? But it's not relevant for the inquiry that he's making right now. All right? All right?
Ms. Pineda, how many times have you been qualified as an actor?
Objection asked and answered.
I sustain the objection. He said over 50 times.
Mr. Matthews.
Carlton Matthews. Yeah.
And then say again, objection.
Asked and answered.
Thank you.
And I sustain the objection. Christine has been asked and answered. He said he testified over 50 times.
Ms. Pineda, have you kept up with the current technologies?
No, I have not.
Was this an old video that you performed video enhancements for?
Yes.
No further questions, Your Honor. Thank you.
All right. Any argument on this particular witness before I go ahead and make a decision? Mr. Adams?
Yes, sir. Just very briefly on behalf of Mr. Williams, the issue before the court is whether or not he should be qualified as, if I'm correct, I think the state is moving to qualify him as a forensic video analyst. Did I get that correct?
Yes, sir. Forensic video analysis.
I would say to the court, Your Honor, based clearly upon the responses to the questions put before this witness, and in consideration of the Daubert standard and Rule 702, that this witness is clearly not qualified under that standard. I would just state the court knows the law, so I will just say that under the Daubert standard, we look towards relevance and reliability of the witness's testimony. Putting aside the relevance, that's not really what we're talking about. We're talking about reliability of the technique, of the proffer testimony that would be offered. And although 702 and Daubert is somewhat flexible, it's geared towards scientific validity and the principles that underlie a proposed submission, in this case, a video enhancement. We don't look towards the conclusion, we look towards the principles and the methodology, and we look towards whether or not there's been a testing of the experts, the proffered experts' theory. There has not been. We look for whether or not there's been publication in support of the expert's method or theory. There's no testimony that there has been any of that. We look towards, the court is advised under Daubert to look towards.
What about his education? Because that's kind of the issue for me is, so we want to talk about that or his experience, I should say. He's been doing this 30 years, so
Education and experience are factors that the court can look to as well, but and I heard the witness testify that he has testified in regards to video enhancements upwards of 50 times. Those 50 testimonies could all have been improper. They could have been wrong because the methodology has to be tested. They could all very well have been done under the Harper standard, which is no longer the law in the state of Georgia. The question before the court is whether or not this witness meets the Daubert requirements, and I would say to the court that simply looking at the responses to the questions, both on direct and on cross, or on voir dire, that he does not. That the witnesses testified that there are no protocols to the methodology used by him. He is unable to indicate whether or not his method or his methodology is generally accepted. There is no peer review. It's not just that he doesn't know if there's any peer review. There is no peer review of his methodology. There is no testimony as to the error rate of his methodology. Under all of those factors, he fails, or this witness fails in terms of being able to be qualified as an expert. And I would ask the court to deny the state's request to qualify this gentleman as an expert.
All right, anybody wish to add to Mr. Adams? What he is, don't regurgitate, but just add if you've got anything to that.
Yes, Your Honor.
Yes, Mr. Johnson.
On behalf of Mr. Eppinger, Your Honor, the court pointed out the education and experience in this particular case. The witness testified that he had performed almost 500 of these video analysis over 30 years. That breaks down to less than 2 per month over the past 30 years. He also testified that he does not have any formal education or no continuing education with regards to these things over the past 30 years. Those are 2 things that he directly testified to. He has not shown that he has the requisite experience in this particular matter to be qualified as an expert, and as such, neither the education, Your Honor. So we believe that under Daubert, he should not be qualified as an expert. Thank you.
All right, anybody else? Okay, all right. Looking at 24-7-702, testimony by expert witnesses. B, if scientific, technical, or other specialized knowledge will assist the trier of fact to understand the evidence or determine a fact and issue, a witness qualifies as an expert by knowledge, skill, experience, training, or education may testify thereto in the form of an opinion or otherwise. Before I forgot, state wish to be heard in terms of argument, in terms of the...
Yes, Your Honor, if the court wouldn't mind.
Sure, I don't mind. No.
Your Honor, so I want to be clear that what we're basing our request to qualify this gentleman as an expert is in the video enhancement, the forensic video enhancement, and we are just referring to that older video. The video is from 2015, so I want to start with that. Additionally, Your Honor, although Mr. Adams correctly stated to Daubert, obviously after Daubert we have Kumho-Tyre, and Kumho-Tyre explains how we can qualify these experts when they don't have, when it's not that scientific process, when it's not that straightforward. Here's a GBI witness, here's what they do, here's a scientific method. Kumho-Tyre provides us an avenue to qualify experts based on experience. And this is going to be something that the court's probably going to hear a lot about with our next witness as well. But basically, with experts like this, the 11th Circuit, and I'd like to point to the 11th Circuit because in Rule 702, obviously this being a new rule to criminal law in Georgia, the legislature has directed us to look to not only the 11th Circuit, but also to all federal courts. But I'll start with the 11th Circuit. United States versus Augustin, that's a 2011 case out of the 11th Circuit, and I can provide all the sites for the court if the court would like me to. In that case, the 11th Circuit said, we note that Federal Rule of Evidence 702 does not define an expert in a narrow sense. And in this case, they were qualifying a gang expert. And the court said, in light of the substantial experience that Agent Young had with respect to street gangs, we conclude that the district court was within its discretion in determining that the agent was qualified to give expert testimony. And this is something that happens a lot. The 11th Circuit, and this is another case out of the 11th Circuit, a 2015 case called United States versus Wilson. In United States versus Wilson, the court held that because a Daubert inquiry must be tied to particular facts of the case. The actual Daubert factors, the ones that Mr. Adams referenced, those Daubert factors may or may not be pertinent in assessing reliability depending on the nature of the issue, the expert's particular expertise, and the subject of the testimony. As such, a district court maintains the same kind of latitude in deciding how to test an expert's reliability and to decide whether or when special briefing or other proceedings are needed to investigate reliability, as it enjoys when it decides whether or not an expert's testimony is reliable.
Okay, but here's the thing I want you to focus on for me, Ms. Rosenwasser. That is, you're asking me to court to qualify him as a forensic video, an expert in area of forensic video analysis. He's not certified by a national accrediting body, which is something that there is an entity or an organization that does provide certification for that particular type of analysis. He has no annual training, and he hasn't been, his competency hasn't been tested. So the principles and methodology are something that the court has to really look at in this case. He's got 30 years of experience, yes, but there are other things that Daubert requires me to look at in terms of a gatekeeping function. You're asking me to qualify him as a forensic examiner. That's different. If he had some of those other things, like certifications, I wouldn't have so much of a problem. Convince me that otherwise, because it looks like from looking at, under Daubert and 702, testimony is based on sufficient facts or data. The testimony is a product of reliable principles and methods, and the witnesses apply those principles and methods reliably to the facts of the case, which have or will be admitted in evidence before the trier of fact. So I have great discretion, of course, and it's abuse of discretion for whatever my ruling is.
Absolutely.
So that's why I'm trying to ask you, given those issues of not being certified by a national body, which there is one, no annual training, and that's just 3, and then there's no competency or testing. So tell me why I should, I should look to, and I've read Kumo. I know about Kumo. Kumo goes hand in hand. That for the non-scientific folks, it lets the courts kind of use that gatekeeping function, because part of the gatekeeping function, am I citing Wilson versus Redmond Construction, it's 359 Georgia Appeals 814. It's a 2021 case, and I have to make this gatekeeping function. It requires me to act as a gatekeeper to ensure speculative and unreliable opinions don't reach the jury. As a gatekeeper, the court must do a preliminary assessment of the reasoning and methodology underlying the testimony is scientifically valid, and of whether that reasoning or methodology can properly be applied to the facts in this case. So the trouble I have is you want me to qualify him as forensic. So forensic indicates to the court that there's some level of training, expertise, certification, peer review, or something to that effect.
So, Your Honor, I was wondering if I could amend my co-counsel's request. If we could qualify him only in the expert in the very limited field of video enhancement.
I would do that.
That's what we would like to have, Your Honor.
I would do that.
Thank you, Your Honor.
All right, Mr. Adams, then I'm going to overrule your. I'll hear your issue, but I believe he is qualified in that particular area of video enhancement. But forensic, I will not qualify him in that.
Your Honor, for purposes of perfecting the record, and
yes,
on behalf of Mr. Williams, we would take exception to the court's rule in that regard. Our argument essentially would be that the same arguments in regards to Daubert and 702 that we proffered previously would apply to whether he's being qualified as a forensic analyst or a video enhancer. And we believe that the statements and the evidence that's been put forth so far do not meet the requirements of Daubert or 702, even under this newly proffered expertise. Well, I'll of course professionally disagree with you. I think that from the court's listening to his testimony, Mr. Pineda's testimony, he's been doing this for 30 years. There is a methodology that he follows, the 4-part division.
that certainly he followed that in this particular case. I think that would be helpful to the jury in this particular matter. So he's not, it's different than being a forensic, because then, forensic, I should say, video analysis. So I'll respectfully overrule or note your objection for the record.
And ask for continued objection, of course.
All right.
And on behalf of Mr. Stillwell, who is directly affected by this evidence as well, we will join in Mr. Adams' argument and adopt all of his arguments in what he has raised.
Okay, if you're not, Mr. Harvey did you all a favor yesterday, okay? Yeah. Unless there's something else, then I'm going to assume that everybody's going to have the same objection or same basis, okay? And continuing objection. Yes, Ms. Sharp.
John, can I just add something?
Sure.
On behalf of Mr. Myra,
Yes.
I understand the court's ruling, but it's still, his methodology has not been tested. And that's the additional thing that I would add. It hasn't been tested, it hasn't been peer reviewed, hasn't been tested. We have no idea whether or not his methodology, the way that he does it.
Under Kumu, have you taken a look at Kumu Tire?
I did, Judge.
526 U.S. 137, 1999. Okay, and that allows the court to look at other factors for non-scientific, and this is non-scientific. It's more so not like chemistry, biology, physics, that kind of thing that can be tested. That can be that there's either a right or a wrong answer. So. I'm required under Kumu to go ahead and at least, if I can look at the other factors in terms of the subject matter of his testimony and expertise, reliability. I'll note your objection for the record. Okay. All right.
But Your Honor, Kumu Tire doesn't apply here. This is scientific analysis that he is doing. I don't understand what can be more scientific than using Fourier transforms, discrete cosine transforms. You're taking it into a different domain.
No, you are, because you're adding things that haven't been testified to.
He testified that he doesn't know.
Okay, and that goes to weight and sufficiency. Well, in terms of, it can go to weight and sufficiency. I have a gatekeeping function, but beside that, you're welcome on cross to take him to task on any of that.
But your gatekeeping function ensures that methods, analysis, that doesn't follow reliable, established standards doesn't get in front of the jury. And this gentleman, while he's been doing it for a long time, is not following the methodology that's established in this industry. He's using his own method.
The Daubert factors, I'm quoting out of Kumu, Daubert factors do not constitute a definite checklist or test, and a gatekeeping inquiry must be tied to particular facts. So, particular facts are, he enhances, he blows this thing up into divides it into 4 parts, and he can testify about that. You're welcome to go ahead, and he's been doing that for 30 years, and certainly the types of videography has changed over that particular period of time. That's what he's going to testify to. You all certainly, there are issues of weight and credibility that I'm sure that you'll go ahead and examine him on. Anything else?
No, Your Honor. Thank you.
Okay, thank you very much, sir. All right, Mr. Johnson, anything else?
Yes, on behalf of Mr. Evans, Your Honor. With regards to the determination that this is such a scientific matter that it assists the jury, his testimony will assist the jury. He has testified that he uses nothing more than Photoshop, which is a product that is sold to the common public and can be used by anybody. So, understanding that Photoshop does not need to be bolstered by his designation as an expert in this particular case. And also, the fact that he said he's been doing this 30 years should not carry weight, given the fact that he's using technology that has not even existed for maybe 10 to 15 years, which he testified that he only uses maybe twice a month based on his own knowledge. So based on those things.
And he's been qualified 50 times in DeKalb, Fulton, Cobb, and Gwinnett, and Fulton. So, all right, thank you, Mr. Johnson. Thank you. All right, Mr. Suri, anything, sir?
Yeah, John Suri Charakimes, on behalf of Mr. Dorsey, we respectfully disagree, Your Honor, and just saying that as he testified, any layperson could do this. we do have an objection as to him being labeled an expert. It will be, again, bolstering. They can just present him as a witness, as the technician that enhanced the video, and explain to the jury what he actually did, not that he has an expertise in that, and not that it's something any different than their investigator or even an intern could have done. So just wanted to say that, Your Honor, that any layperson could do what he's doing, and that is what distinguishes an expert. Thank you.
Ms. Rosenwasser, one more thing. What about the issue of somebody? I mean, Photoshop he used Photoshop in this particular case, didn't he?
Your Honor, could I ask him?
Mr. Pineda, did you use what program or did you use to enhance the video in this case?
Photoshop.
Photoshop. He did. All right. So what's to say that, as Mr. Suri mentioned already, about anybody else being able to use Photoshop?
Your Honor, my understanding from...
Because I don't need to designate him as an expert for him to testify.
Absolutely. When we went to qualifying, we wanted to do this out of essentially an abundance of caution to ensure that maybe the jury would want to know how that these were enhanced, and we thought that he would be able to explain that based on his years of testimony and experience. So my understanding is that based on his experience, my understanding to the answer to the question where he mentioned that anyone could do this, it was not only that anyone could use Photoshop, but anyone who knows how to use Photoshop and learns over a period of years how to enhance better on it. But should the court wish to find he is only admissible as a lay witness, we'll put in the videos through him as a lay witness. That's fine too. We just want to get the videos in. I don't care who they come in.
Mr. Jimenez, you convinced me. I do believe that given the fact that this is a readily available program, Photoshop, and that anybody with a varying level of skill and practice can do that, I won't qualify him as an expert. I'm just going to let him testify as a layperson for the above mentioned reasons. Okay? All right?
Thank you, Your Honor. We'll call him as a lay witness.
That's fine. All right. Mr. Pineda, I'm gonna go ahead and excuse you as a witness. Appreciate your patience with us, and the state will call you, or the defense will call you. You might get a call from Mr. Menendez over here to interpret, but that's a separate issue, okay? And make sure you're patient. All right. So, but please don't discuss your testimony with anybody except the attorneys in this case, okay? All right. Thank you, sir. All right, counsels and those who are interested, before I take up your next witness, you have the other witness, Mr.
Investigator Hall. Yes, Investigator Hall is here, Your Honor.
Okay, let's just pause on him just a second. Do you have your other witness related to Mr. Stillwell's motion to dismiss?
Your Honor, we are not ready on that right now. We can be ready for that immediately after Investigator Hall's testimony.
How come he's not here? I thought you all said you're gonna have him available.
We can make him if Your Honor can give me 10 minutes, I can get everybody down to do that hearing.
That's fine. Let me give you 10 minutes. I have to, there's something else I need, unrelated court business I need to take up. So let me go ahead and deal with Mr. Stillwell next, and then we'll start on Mr. Hall probably this afternoon. But let's go ahead and get Mr. Stillwell done first, okay? So we're going to recess about 15 minutes, and we'll go ahead and...
Can we keep Investigator Hall here, Your Honor?
Hang tight, hang tight, hang tight. Have him come back for 1 o'clock, please, madam, okay?
Okay, thank you.
All right. Okay, we're in recess.
Thank you.
All right, we ready? Everybody back? Okay, all right. Good afternoon, Ms. Love and Mr. Armstrong.
Good afternoon, Your Honor.
Okay, all right, so Ms. Rosenwasser, where are we now with the issue involving Mr. Stillwell? Could we have that witness?
Yes, Your Honor, and the hearing is going to be handled by Mr. Armstrong's log.
Okay, what is the name of our witness?
Deputy District Attorney Michael Sprinkle, Your Honor. S-P-R-I-N-K-E-L.
Okay, all right, some of Mr. Sprinkle.
Yes, Your Honor.
Your Honor, for the record, I'd like to invoke the rule of sequestration.
All parties who are going to give testimony in this case, you can step outside at this point in time. Please don't discuss your testimony except the attorneys in this case.
Your Honor, I'm sorry, the DA's office is speaking to the mic. We have a hard time hearing back here.
Yes, please.
Long just did.
Is Mr. Sprinkle on his way, or is he,
He's here, Your Honor.
okay, all right. You can summon Mr. Sprinkle, please.
They are getting him. He was outside, Your Honor. Okay, I don't know, he must have stepped outside. Who? Mike. It's okay, we will. It's no problem. Oh.
Oh, he went to
Your Honor, Deputy Sprinkle is coming to this courtroom from 8F. He erroneously understood us to be there. My apologies to the court.
Okay.
No, it's this one.
Yeah, I mean, I just wanted to let you know. I wasn't. I didn't mean to.
Thank you very much. You're going to react on to the introduction of this. What have been happening?
Matter. If I anticipate going to go into the facts of this case a little bit, hopefully not more than necessary, and I will not try to go anywhere unnecessarily. Are we to continue, I mean, we have trial January 9th. Are we to continue to be using
initials, pseudonyms? Where are we with that? Because I don't.
And I've been asked to do that, so this is your motion. So you need to use whatever names. Hold on, Mr. Sprinkle, 1 second. 1 sec, Mr. Sprinkle, hold on 1 second. So is that what you're asking?
Well, I just don't want to violate anyone's court orders or get in trouble for anything. And I'm going to do my best. I mean, I know people by names, but
Well, I haven't said otherwise. I mean,
Okay.
so,
All right.
no, I mean, that was a time period line in the sand for information to be provided. So,
we're past that.
yeah, we're past that.
Thank you.
Ingram, maybe we're getting some more phone calls. Answer that for me, please. Huh? No, different. I blocked that last one. Okay, is that clarified, Mr.?
Yes, Your Honor.
Okay, all right. Okay. All right, Mrs. Sprinkle? Sir, if you would be so kind, once you drop all your materials, to approach the witness stand, and Deputy Ingram will be swearing you as a witness, okay?
Yes, Your Honor. You raise your right hand. You swear affirm the testimony you give the truth, the whole truth, nothing but the truth.
I do.
Have a seat. Take your first and last name, and spell first and last name.
First name Michael, Michael. Last name Sprinkle, Sprinkel.
Good afternoon, Deputy Sprinkle. How are you?
Very well, thank you. How are you?
I'm well, thank you. Deputy Sprinkle, would you please tell the court where it is that you're currently employed?
I'm currently employed at the office of the Fulton County, Georgia District Attorney.
And what capacity are you employed there?
I'm a Deputy District Attorney.
How long have you served the Fulton County District Attorney's Office as a Deputy District Attorney?
Since June 21st, 2011.
And when did you first begin with the Fulton County District Attorney's Office?
June 21st, 2011.
What area do you work in within the District Attorney's Office?
I am the head of the unindicted homicide unit. I review all of the murder cases that come, well, not just murder, all homicide cases that come into the office from the various police agencies in the county.
And you made a distinction between murders and homicides. Why is that?
Well, it's not just murder. There's felony murder. There's involuntary manslaughter, voluntary manslaughter, homicide by vehicle in the first degree, etc.
Have you always served as the head of the unindicted homicide unit?
No.
Before serving as the head of the unindicted homicide unit, what did you do within the District Attorney's Office?
For approximately the first 3 months of my employment in the DA's office, I was assigned to what was called at the time the complaint room, which was a 24-hour operation in which I would receive or be assigned cases that were coming in live, essentially. Somebody had just been arrested and the police would send a report. I would review it, speak with the officer, draft some sort of affidavit to summarize the case, and otherwise ready the case for first appearance the following morning. Following that, I was assigned to the non-complex division. I was in that division for 3 to 6 months. Sounds about right. That involved the prosecution of cases that were deemed non-complex, such as possession of cocaine and theft by taking under a certain value. After my time in the non-complex division, I was assigned to the complex trial division for about a little less than 2 years, signed to Judge Schwall's courtroom and then Judge Constance Russell's courtroom. And then in October of 2013, I was assigned to the unindicted homicide unit, albeit I was not the head of the unindicted homicide unit, though if memory serves correctly, I was the only attorney in the unit, so I suppose in a way I was the head, given that I was the only one. But then as time went on, the unit expanded. I was promoted, and now there's more employees in the unit. And now I'm the deputy in charge of it.
Within the homicide unit of the District Attorney's Office, do you receive cases involving homicides where persons are charged or already arrested?
Yes.
And is it always the case that a person has been charged or arrested when you receive a file within the office?
No.
When you do receive a file wherein a person has been arrested, do you immediately present that case to the grand jury?
No.
Why is that?
Well, I want to ensure that the person who's been charged or arrested primarily committed the crime that is alleged they committed. So in order to do that, I inspect the case file, which primarily, if not, well, I don't want to say exclusively, because there are some things that I find on my own, but when I'm preliminarily looking at a case file, I look at what the police have sent me, their reports, their interviews, cell phone records, the extractions of cell phones, when the police actually copy the data out of somebody's cell phone. And I just go over all of this to make sure it's consistent with what has been alleged in the arrest warrants.
And do you always have all of the information within the case file given to you by law enforcement that you feel you need in order to fully complete the investigation on a homicide?
No, not always, no.
And what types of steps do you take to ensure that you have obtained as much information as you can? Do you, for instance, do you pull jail calls?
Yes.
Do you speak with witnesses?
I do, on occasion, yes.
Do you go to scenes?
Objection, Your Honor, leading.
Your Honor.
Is it a preliminary matter? Is it preliminary matters?
Thank you.
I'll allow it. Over your objection.
Thank you, Your Honor. Do you go to scenes?
Yes.
Do you seek search warrants?
Yes.
And do you present evidence to other entities for further testing?
Yes.
And does that always take limited amounts of time, or is that sometimes more protracted?
Well, it depends on the case and the volume of deficiencies that I have identified in the initial investigation.
Bringing you to the case involving the murder of Donovan Thomas, do you recall when you received that case file within the district attorney's office?
Would have been late, probably December 2015, January of 2016, somewhere around there. It's actually probably going to be January of 2016, to be more exact.
And without going into specifics about what that was, at the time that you received that case file, was it complete to your satisfaction as an assistant district attorney?
Well, it depends on how you define the word complete. Was it complete insofar as the Atlanta Police Department was concerned? I don't know. I know that they handed me everything that I asked for. If there were some other documents that the Detective Thorpe still had in his file they just didn't give to me, I have no way of knowing that. As far as I know, what the Atlanta Police Department gave me was the complete case file.
And did you review that complete case file that you received from the Atlanta Police Department?
I did.
Upon reviewing that case file, were you satisfied that the case was sufficient to present to the grand jury as you received it at that time?
No.
Did you take additional steps to investigate the case?
Yes.
Now, at the time, a person had been arrested on the murder, is that correct?
Yeah, at least one person had been arrested on the murder.
And that person was the defendant Shannon Stillwell?
Yes.
Shannon Jackson?
Yes.
From what you were able to gather from the file that Detective Thorpe gave you and from your subsequent investigation of the case that you did, was Mr. Stillwell the only person of interest in that case? Was he the only alleged participant in the homicide?
Well, no, there were three other. If we're talking about the people that had been charged by the police, there were four.
Okay, go ahead.
There was Antonio Sledge, Demikian Garlington, Kenneth Copeland, and Shannon Jackson, a.k.a. Shannon Stillwell. Those were the four people that the police charged for the murder of Donovan Thomas in late 2015.
And were you able to determine, based on your review of the file given to you by Detective Thorpe, what primarily those arrests were based on?
They were primarily based on the statement of a young man named Spencer Wright.
All right. And when you received the file from Detective Thorpe, did you endeavor to speak with Spencer Wright yourself?
I did.
Why is that?
Well, so Spencer Wright, according to his statement, he witnessed the homicide, the drive-by shooting, as he stood at a bus stop on McDaniel Street across the street from the barber shop, the parking lot of which Mr. Donovan Thomas stood when he suffered his fatal gunshot wounds. There was a surveillance camera mounted on that barber shop, and the bus stop where Mr. Wright said he stood was in the viewing area of that surveillance camera. And when I looked at the footage, I didn't see anyone standing at the bus stop. I saw a cat at one point milling about the the bench at the bus stop, and I only bring that up to indicate that the clarity was sufficient to tell if there was a human being standing there. There was no human being standing there. So what I wanted to do was speak with Mr. Wright and show him, I believe I printed off some still images. I don't think I brought in like a computer or something to show him the actual footage. So I wanted to speak with Mr. Wright and make sure, first thing I did is I wanted to speak with him and make sure that I was clear as to where he was standing. So I actually, before I confronted him with the fact I didn't see him on the video, I had some printouts from Google Earth, and I asked him to point to the specific bus stop where he said he was standing. And when he did, he pointed to the bus stop that was depicted on the surveillance footage, at which point I said, but there's nobody standing at that bus stop. And he didn't really have an explanation for me.
Did you receive that surveillance footage from the Atlanta Police Department?
Yeah, yes.
Did you, as you stated, you pulled Google Earth images. Was that something that you had received from the Atlanta Police Department, or is that something that you did to further your investigation?
That was something I did to aid in my interview with Mr. Wright. I just pulled up Google Earth and took screenshots of the bus stop and the general area where the homicide occurred so he could point to them and indicate where he stood, where he claimed to have been standing, I should say.
And why did it concern you that he was not shown in the surveillance footage that you presented to him, yet he claimed to have witnessed the homicide?
Well, he claimed that the bus stop was his vantage point from which he witnessed the 4 defendants that I mentioned earlier occupying a vehicle and commit the drive-by shooting. If he wasn't standing at the bus stop, that would suggest he didn't witness it at all.
Was there anything else that you were able to uncover during your ensuing investigation of this case that enlightened you more as to whether or not Mr. Wright was presenting to you information that was factually accurate?
Yes, so after my interview with him, I requested from the Atlanta City Jail, because that's where he was when I interviewed him. I interviewed him inside the Atlanta City Jail. He was an inmate there. From somebody that worked at the Atlanta City Jail, whose name I don't recall. But I asked him to send me Mr. Wright's recorded jail calls, because just like the Fulton County Jail, at least at that time, the phone calls placed by inmates from the Atlanta City Jail were recorded. So when I obtained Mr. Wright's jail calls, I found one that was he placed shortly after his arrest to a gentleman. And during this call, and this is, by the way, not verbatim, okay? I'm not quoting him exactly, but he told his friend about his recent arrest, which I believe was on a probation violation, and he said that everything would be okay because he was helping the police solve a murder. And his friend asked, well, what murder was that? He said Nuts murder, and that Nut would be the moniker for Donovan Thomas. And his friend scoffed at him and said, but you didn't witness that. And Mr. Wright responded, he basically shushed him, reminding him that they were on a recorded jail line. But the implication there was that he didn't witness it, and he would prefer that his friend not, utter such a thing on a recorded jail phone. And then he said, but it's something to the effect of, it doesn't matter, we all know what happened anyway. And it's also worth mentioning that during my interview with Mr. Wright, very soon into the interview, something that caught my attention was, he said, you see, I've been on Instagram, or again, not verbatim, but he mentioned that he had been on Instagram and putting the pieces together from there, which put up a red flag, made me think that perhaps he was just compiling a statement through rumors that he saw on the internet. So after I heard that jail call, I asked investigator David White. I knew who he was talking to. I can't recall his name off the top of my head, but the gentleman that he was talking to, and the same gentleman that said, but you didn't witness that, et cetera. So my investigator reached out to him and asked him, well, how did you know that Mr. Wright didn't witness the murder of Donovan Thomas? And he said, well, that murder was a really big deal in the city, and I'm pretty close with Mr. Wright, and he never mentioned to me that he had witnessed it, and it's the kind of thing that he would have mentioned had he witnessed it. So at that point, I was satisfied that Mr. Wright didn't really witness the murder at all, and he just made it up.
Why didn't you just go ahead and present the information to the grand jury as had been presented to you by the Atlanta Police Department? People had been arrested. Is it an imperative that you immediately get the case indicted?
Objection.
Who's made the objection?
Self-serving.
I sustain as to form. You can rephrase it. You can rephrase it.
Yes, Your Honor. Mr. Sprinkle, Is there any reason in particular why you did not go ahead and present the indictment to the grand jury with the names and the information that had been given to you from the police department?
Well, for one thing, I'm not the one who decides what cases are presented to the grand jury, but if I was, I still wouldn't, because at that point, out of 3 of the 4 defendants, I had a complete absence of evidence that they committed the murder at all, and I wouldn't present a case naming a specific individual. I wouldn't present an indictment to a grand jury wherein a specific individual is alleged to have committed a crime when there's a total absence of evidence that they actually committed the crime. That would actually violate state bar rules for me to do that.
And Your Honor, if the court would, just so that I'm aware, is there any other party to this defendant Stillwell's motion to dismiss that I'm unaware of? Because
I have not, the court is unaware of anybody else who's joined in this particular issue.
Okay.
So.
Your Honor, if I can answer that now, Mr. Dorsey, the state keeps saying that because this is RICO, everything applies to everything. I have adopted the motions of everybody, so I do reserve the right to ask some questions of the witness, Your Honor, but based on the theory that the state says that because it's RICO, everything applies to my client, I do want to make it very clear. I can have nothing to do with this.
Your Honor, this is Shannon Stillwell's assertion of his constitutional right to a speedy trial. I do not believe that Mr. Chadha or his client have any right to assert as it relates to Shannon Stillwell's assertion of his right or the denial thereof to a speedy trial. And I would ask that the court limit questioning and argument and commentary to the parties that are involved in this particular motion.
Your Honor, as it relates to Mr. Marquavius Huey, he has nothing to do with it as well in terms of the specifics of a murder. However, he's a part of this indictment.
Yeah, Ms. Love, the issue you're going to have is that since it's a RICO case and anything can be attributed to any other defendant, that's why that they have a right of confrontation as to this. Now, so the specific relief is only available to Mr. Stillwell, but counsel are entitled to ask other questions as they see fit.
Yes, Your Honor. Thank you, Your Honor.
All right.
Your Honor, if I may, just to be clear, on Mr. Williams' behalf, we do claim an interest in the outcome and the argument of this motion. We understand it's Mr. Stillwell's motion, but again, as the court has indicated, because this is a RICO indictment, Mr. Williams is charged in it, he has an interest and an ability to pose objections if necessary.
Deputy Sprinkle, after you determined that the information that you had been given was inaccurate or could not be verified, did you take additional steps to investigate the homicide, the murder of Donovan Thomas?
I did.
And would you tell the court whether or not this was a sort of high-profile case within the office?
It was.
And are you able to say what impact the case itself had on the office or on the city of Atlanta that caused it to be a high-profile case?
Basis.
Irrelevant. What does high-profile case have to do with anything?
All right.
I'll respond, Your Honor.
Why don't you explain that for our rule?
Thank you, Your Honor. Your Honor, the reason that I asked about it being a high-profile case is to sort of lay the groundwork for the fact that the office did not seek to not investigate or to not make sure that we got the case right. By asking whether it was a high-profile case, it's to bring out to the court the mindset with which Deputy Sprinkle investigated the case.
Yeah, I'm going to overrule your objection. Go ahead, ma'am.
I just want to
Thank
be
you, Your Honor.
clear.
I've overruled your objection.
Did that murder carry with it a series of violent shootings within the city of Atlanta?
Yes, for many years following that.
Basis. Why don't you rephrase?
I can do that. Thank you, Judge. After the murder of Donovan Thomas, were there multiple shootings within the city of Atlanta within days, sometimes weeks of one another?
Objection, relevance.
I
There's
have
multiple
one
shootings
basis.
going on in Denver.
I'm gonna let her finish, okay, and then I'll okay? All right, go ahead, madam.
Thank you, Judge. Were there multiple shootings within the city of Atlanta?
Yeah.
Objection on irrelevance.
I was gonna say this to leading. Why don't you ask him what happened as a result of that, if he knows, if any?
After the murder of Donovan Thomas, and let me back up, were there any gang implications to the investigation? In other words, during your investigation and during your initial review of the file, was there any indication from the information that you had within the file that the murder was gang-related?
Yes.
And what gangs were alleged to have been involved?
Englewood family, that was the gang to which Mr. Donovan Thomas was a member, a high-ranking member, and the other gang was YSL, or Young Slime Life, to which Mr. Williams was a member.
Did you gain knowledge?
I'm going to object to that
Basis.
answer.
Basis.
Speculation, and after to be stricken.
I'm gonna overrule the objection. What's your objection?
It's a legal conclusion. Criminal street gang is a legally defined term, has to be determined by 12 people from the city.
That may be in front of a jury, but this is the district attorney's investigation. I'm going to overrule your objection.
In Your Honor, so just so I'm clear, we are speaking just in layman's terms when we say gang at this moment, not in legal terms.
I'm still going to overrule your objection. Okay, thank you.
And during the weeks and months following Donovan Thomas's murder, did you have information that led you to believe that a series of retaliatory shootings between YSL and Englewood family took place across the city of Atlanta?
I'm going to object because it calls for hearsay.
Your Honor.
Go ahead.
Your Honor, the defendant, Shannon Stillwell, has alleged an intentional delay on the part of the state. What led us to further our investigation, and what information we had?
Goes to conduct?
Yes.
All right, I must overrule the objection.
Thank you, Your Honor.
Okay.
Did you have information that led you to believe that a series of retaliatory shootings between YSL and Englewood family happened after Donovan Thomas was murdered?
Yes, there were cases where the victims were identified as YSL or Englewood family, and the shooters were also identified as YSL or Englewood family, and commonly the shooters would generally be in the rival gang. I don't want to say there were no cases that involved the same members of the same gang shooting at each other, but primarily it was opposing gangs that were shooting at each other. The participants that were identified were in opposing gangs. Those two gangs specifically, yes.
Okay. And during that time, did you and the Fulton County District Attorney's Office gang unit work closely with the Atlanta Police Department in an effort to solve the murder of Donovan Thomas, as well as find out whether or not those series of shootings were related, in fact, to the murder of Donovan Thomas?
The gang unit, the office's gang unit, I believe they were in consultation with Detective Thorpe, but I don't recall speaking with Detective Thorpe prior to him obtaining warrants for the arrest of the 4 men that he originally charged.
And that is before the arrest of the persons that were originally charged. I am speaking of during the months in the year 2015, 2016, did you obtain more information that led you to believe that the murder of Donovan Thomas was gang-related?
Right. Well, yeah, I would routinely consult with Detective Tyrone Dennis with the Atlanta Police Department. He also worked very, very closely on the murder case and alongside Detective Jim Thorpe Jr.
And were there incidents, shooting incidents that took place, and other incidents that took place that involved members of the alleged offending gang or YSL?
Yes, either, as I said, the victim was identified as being in one gang or the other. The shooters are identified as being in the opposite gang. There were shell casings that, when placed under microscopes and the tool mark on the back of the casing was compared to various incidents, they would find that similar guns, or the same guns, I should say, were used in these various incidents, which could possibly indicate that the same participants were involved.
And did you prepare a supplemental report to the case file that you have been given by Detective Thorpe in order to outline the investigation that you conducted in this case between the time that you received it and November 13, 2018?
Yes.
I am showing to you what has been marked as State's Exhibit 1.
Yeah, Ms. Love, we're going to just use the next exhibit in order. So what's that, Ms. Rosenwasser?
11.
Would the court like for me to then label it State's Exhibit?
States 11, yes, ma'am, if you wouldn't mind, please.
I sure will. I'm showing you what has been marked as State's Exhibit 11. SS. Would you take a look at it? In Your Honor, I will, at the end of this tendering of this exhibit, ask that the court allow me to tender a digital copy of this as evidence. Under seal.
Okay. Yes, I've looked at State's Exhibit 11.
Does State's Exhibit 11 contain the supplemental report that you prepared outlining and detailing the investigation that you conducted up until November 13th of 2018?
It does, but as you can see, I brought a copy of my report to the stand with me anyway, and it looks like there may be a page missing from this one, because my report has a page that only has about 2 sentences on it, but so this may be a page short, basically.
And
Your Honor, just Sudi Chava, the other could please be provided a copy of the report that he has.
Oh, never mind. There it is. Yeah. Okay.
If it was, or?
After he just testified that he's missing some sentences, so we just appreciate we get a copy of whatever he's actually looking at.
He would be entitled to, he would be required to update that particular as part of continuing discovery. So to the extent, Ms. Love, you have not done that, go ahead and do so, okay?
Thank you, Your
All
Honor.
right, okay.
Deputy Sprinkle, would you please clarify for the court whether or not the page you were referencing is contained within State's Exhibit 11?
It is. You just turn the page over. It turns out I guess it was facing the wrong way. So no, that's my full report.
Thank you. Your Honor, the state tender State's Exhibit 11, and with the court's permission, I would like to enter evidence digitally under seal.
Okay, so granted.
Your Honor, I object.
And Your Honor.
Basis? Is this part of the order that I entered before?
No, it's not.
Why do you want to enter it under seal, madam?
Only because it contains information, personal information about witnesses. The defense has been provided this report on August the 8th, I believe, 2022 in its entirety. I am happy to let defense counsel look at it, review it, and compare it to their copy of the discovery that has been previously served.
Okay.
But my issue is not with under seal per se.
Well, then I'm going to seal it then, okay?
All right. No, it's not with that. My issue is admitting we're having a.
Well, you're
It's
okay.
hearsay.
No, but you've made it an issue for the purposes of your speedy trial demand.
Right.
So they're introducing as part of what they, as if I understand it, given the factors, is that what they did and the reason for the delay. Is that what you're doing, Ms. Love?
Yes.
So I mean, so that's why they're introducing it for that limited purpose. So.
With all due respect, Your Honor, He can testify to what he did.
He just did, but in terms of if the case goes up on appeal, then of course the appellate court will have an opportunity to take a look at it.
For the record, I would just like to say that there's a lot more in that report than what he's testified to through live testimony. And we are objecting to conducting this hearing through proffer, which is essentially what we're doing.
Well, you got live testimony because you haven't even examined Mr. Sprinkle yet. So you certainly will be able to do that. But I'm going to admit it and seal it over your objection to States 11, okay? And you'll be able to get with Ms. Love and her colleagues and take a look at it, the original, the discovery that you were provided back in August in relation to this particular document, and the state will need to, of course, disclose or lets you give you that particular evidence, anything discovery they haven't done so far, okay?
And we will be able to cross-examine Mr. Sprinkle on all of the contents of that document that's being admitted as evidence. But I want to make sure we're able to do.
If they're introducing in evidence, yeah, you get to cross them about anything you want in terms of that particular document.
Thank you, Your Honor.
Deputy Sprinkle, did your investigation into the murder of Donovan Thomas cease entirely as of November 13th, 2018?
No, it didn't.
Would you just briefly encapsulate some of the additional investigations that you participated in or conducted between 2018 and May 2021?
Okay, so in 2019, there were at least 2 gang-related murders that involved the YSL Street Gang and the Englewood Family Street Gang. One was a February 23rd, 2019 murder involving a victim named Jamari Holmes and some YSL gang members named Damone Blaylock and Rodalius Ryan. I did a lot of work on that case. But for purposes of this hearing, I did a search warrant to Instagram for, I believe it was 4 or 5 accounts belonging to YSL gang members. Now, the reason why is that search warrant was for the accounts of the people that were participants in the February 23rd, 2019 murder of Jamari Holmes, of course. But with any search warrant that I did for concerning either one of those gangs, the murder of Donovan Thomas was always really just on the front of my mind because that.
Why?
It was the murder of Donovan Thomas that was essentially the primary genesis of the dispute between these 2 gangs that had claimed the lives of so many people and wounded countless others. So I always, when investigating any case.
This is irrelevant.
Madam.
Your Honor, Deputy Sprinkle is talking about the investigation that he continued to conduct into the murder of Donovan Thomas and why it is that he did what he did during that investigation. If, again, the state's intent is at issue, Mr. Sprinkle's steps taken during the investigation are reflective of the state's intent.
Okay. I'll overrule your objection, sir.
May I respond to that?
What is it you want to tell me? I mean, I've overruled the objection, so what more do you want me to know?
The state just proffered evidence, and I don't think that's correct, Your Honor.
Well, then cross-examine him when you got him on cross.
I understand.
So you're a little, you're a little early, okay? When you got him on cross, you can ask him these questions that you're not allowing them to answer right now. But it's relevant for the purposes of delay and the reason for delay. So can we move on from that? Okay.
In May of 2021, was the case involving the murder of Donovan Thomas turned over to a specific team in the district attorney's office as part of a broader investigation?
It was.
All right, and who was it turned over to?
Don Geary was the primary attorney on the case.
And is that case, or did that case form the basis for the indictment that the defendant sits on today, charged with both the murder of Donovan Thomas and the murder of Shamel Driggs?
Yes, yes, it is, because I at that point was consulting with my coworkers and recommending that we pursue an indictment on the murder case, at which point the others determined that a team should be assembled because this case encompassed a lot more than just the murder of Donovan Thomas. So at that point, my case file was handed, but that was the first step, was my investigation into the murder of Donovan Thomas. And then I wasn't working very closely with them. I would of course answer their questions, of which they had many when they had them, but I wasn't in a room working with them on a daily basis. But from what I understood and what would eventually see when the indictment came out, was they were working on this vast RICO case.
And are you aware of a wiretap being used to gain information in furtherance of the investigation of this RICO case that you referenced just now?
Yeah, I drafted all the documents associated with it and performed the minimization procedures and reviewed periodically would spot review the work of the modders.
And was that in April 2022?
I believe so. Yeah, I believe so. April 2022. I think towards the end of that month, yes.
And did the investigation that took place between the time that you were given the file by Detective Thorpe and the time that this case was initially presented to the grand jury form the basis for the indictment 22 SC 183572?
Yes.
Thank you. Just one moment, Your Honor.
Yes, ma'am.
Deputy Sprinkle, between November 2018 and May 2021, did you work with any other prosecutors on this case or on the investigation involving the murder of Donovan Thomas?
Well,
did you at any time work with Deputy Kara Convery?
oh, yes. Deputy Kara Convery and I spoke about this case and exchanged information on a regular basis throughout the entirety of the investigation.
And where did Deputy Kara Convery work within the District Attorney's Office?
She was the head of the gang unit. I don't recall which year. I know Gabe Banks was the head right when the case came in. I believe you were the head of the gang unit at some point. And then Kara Convery, probably by 2019, she was the head of the gang unit.
Was there ever a time, Deputy Sprinkle, that you delayed this case to get a tactical advantage over the defendant, Shannon Stillwell?
No. I didn't want to delay the case at all.
And was this a case of average complexity?
No, this is an extremely complex case.
Just one moment, Your Honor. That's all that I have for now.
All right, Mr. Sharp, go ahead, sir.
Mr. Sprinkle, how are you doing today?
Very well, sir. How are you?
I'm good. Thank you for asking. As I understand it, your role in the DA's office is you receive a case file from APD.
Well, many times, most of the time actually from APD, but there are other agencies in Fulton County, of course.
And you work on that case file and bring it up, build it up for indictment if you feel that is warranted.
Correct.
Okay. But you did tell us that you are not the person who decides when to indict a case.
That's correct.
Who is that person?
Well, back in 2015, 2016?
Yes.
That would have been the District Attorney, Paul Howard.
That was Mr. Howard back in 2015 and 2016. Okay. How long did Mr. Howard have that decision-making power on when Shannon Stillwell would be indicted on the 2015 case?
Well, presumably all the way up until the last day of 2020. I believe that was the last day he was in office. I could be wrong about that, but it would have definitely been around that time.
And who took over that decision-making power in 2020?
The current DA, Fonnie Willis, and her and her agents, people like myself and Adam Boddy and Pat Dutcher.
Okay. So when Ms. Love asks if you delayed the indictment to get a tactical advantage on Shannon Stillwell, it wasn't even your decision, was it?
That is correct. That is correct.
That question about choosing when to indict from 2015 to 2020 should be asked of Paul Howard, correct?
I cannot.
Objection, Your Honor.
Basis.
The question about whether or not the decision to indict should have been left to Paul Howard is not proper. It does not speak to Deputy Sprinkle's actions and steps that he took during this investigation in order to make sure that it was thoroughly vetted.
They tried to create the impression that Mr. Sprinkle's the one that called the shots, and he's clearly not. And now that I've asked him about it, and it's clear he didn't, now it's irrelevant. They asked him if he delayed the indictment of Shannon Stillwell. I'm saying it was delayed, and my client has been prejudiced, and I want to hear from the person who made that decision.
Well, it's one factor that I'll weigh, Mr. Shart, so go ahead and move on. Because we've had another district attorney since then, and it's part of the overall investigation. So his response might be, I'm assuming it's correct, but certainly has to be looked at in terms of the continuum of other things that went on in this case. So, and I'm sure you're going to examine him about those.
Yes, Your Honor. And so starting in 2020, the decision-making was DA Fonnie Willis.
2021, yes.
2021. All right. Okay. When was Shannon Stillwell charged in this case?
I believe it was September of 2015.
Okay. And if I suggested that was October 2015, would you dispute me on that?
No, I wouldn't.
Okay. And would you dispute that he was arrested in October of 2015?
I'm quite sure it would have been around that time, the last quarter of 2015. Based on when I received the case file, that would be in line with that.
And he was placed in jail?
He was.
Okay. Now, my client, Mr. Stillwell, was charged in 2015, October 2015. Who else did you say was charged at that time?
Antonio Sledge, briefly, because his case was dismissed at the preliminary hearing.
Okay.
Kenneth Copeland and Demikian Garlington.
And that's the same Kenneth Copeland that is on the state's witness list?
Yes.
Okay. And it was Detective Thorpe of APD that made the decision to charge my client, Mr. Stillwell?
Yes.
And it was Detective Thorpe of APD who made the decision to charge Mr. Sumlin, Mr. Copeland, and Mr. Garlington?
Mr. Copeland, Mr. Garlington, I believe you meant to say Mr. Sledge?
Sledge, I'm sorry.
Yes, yes.
I said Sumlin instead of Sledge.
Yes.
And you're telling us that the decision to charge those 4 individuals was based on the word of Spencer Wright?
Well, for 3 out of 4 of them, if my memory serves correctly, it was essentially entirely based on Spencer Wright. Your client, there was a little bit more evidence.
And we're going to get to that, and I appreciate you bringing that up. So, but for the other three, well, for all four, a man named Spencer Wright claimed to be at the scene of the murder and named those people as being involved.
Yes.
And when Spencer Wright, are you aware of the circumstances that brought Spencer Wright into contact with Detective Thorpe to tell Detective Thorpe this?
Generally, yes.
Did Spencer Wright have pending charges?
Spencer Wright had been, if my memory serves correctly, I know that he didn't just show up to the precinct out of the goodness of his heart. He had been pulled over, if I remember correctly. During the traffic stop, he threw a gun away in the bathroom at the gas station. He lied about his name, and there was an investigator, Lakia Gaither, just happened to recognize him and reminded him of what his name actually was. So he was, so he had a firearm, and I believe he had a probation violation warrant. So he was taken into custody contemporaneously with his statement.
And so we're clear, you wouldn't dispute that Spencer Wright had a motive to lie?
Yes.
That would be correct?
Yes.
Okay. And Spencer Wright actually came in at the same time that he named these four individuals as being involved in this murder and gave police a false name?
He did at first, and one of them, like I said, just happened to know him. And this is all from memory, but I'm pretty sure this is correct.
So he lied about his name?
He did.
And the police knew this?
Yes, they did.
And they took his word on who to arrest on a murder?
That's what happened, yes.
Okay. And through your investigation, you would agree that 3 of the 4 defendants in this case have changed since then regarding the 2015 shooting.
3 out of the 4, okay, so first of all, what do you mean by change, and which 3 defendants are we talking about?
There was 4 people that were charged in October of 2015 by Detective Thorpe. 3 of those 4 people are no longer charged.
Oh, I understand. In other words, we ultimately indict a different set of people than were ultimately charged by the police. Is that your question?
Yes.
Yes, that is correct. We did indict Shannon Stillwell, aka Shannon Jackson, who's your client, but we did not charge Mr. Copeland, Mr. Garlington, or Mr. Sledge with the murder of Donovan Thomas.
Well, let's be clear. They were charged.
They were charged by the police, yes.
And they were arrested and put in jail.
They were, yes.
Based on the word of Spencer Wright.
That is correct.
Who lied about his name?
He did.
And in those 3 people's place that were eventually released, 3 new people have been charged.
That's, well, 4 people actually, but yes.
Okay. 3 new people and Mr. Stillwell.
Yes.
So essentially what we're saying in layman's terms is Detective Thorpe added 250.
Objection, Your Honor. Relevance and just unnecessary. Detective Thorpe batted 250.
I'm a sustaining objection.
So you have your report, correct?
I do.
All right. And your report is approximately 100 pages long?
140, I believe.
140. Okay. And you began working in January of 2016?
That's correct, yes.
And on page 2 of those 140, well, let me back up, I'm sorry. Almost the first order of business in this report is your concerns about Spencer Wright.
Correct. That is how my investigation began.
Because you were doing a thorough investigation and you looked at the video and noticed the man who was saying he witnessed the event was not where he said he was.
Correct.
Okay. And so your report, this 140-page report, begins with discussion of the video and Spencer Wright.
Yes.
On page 2 of the report, in the first paragraph, you talk about Detective Thorpe finding probable cause for these 4 individuals that are originally charged.
Yes.
And then you say, Kenneth Copeland, Demikian Garlington, and Antonio Sledge, or I'm sorry, you say Copeland, Garlington, and Sledge consisted almost entirely of the statement of Mr. Spencer Wright, correct?
Correct.
All right. You went on to say, with respect to Mr. Jackson, Mr. Wright also implicated him in the statement summarized below. However, there was another witness named Quindarius Zachary that also implicated Mr. Jackson.
That is correct.
Okay. So on page 2 of the report, you were saying that there was an additional witness against, when I said Mr. Jackson, you were calling a Mr. Jackson report, but it's my client, Mr. Stillwell.
Yeah, back then he was known as Shannon Jackson. That's why I say Shan Jackson, a.k.a. Shan Stillwell, or vice versa.
All right. You, as the investigator, did not have the same doubts or concerns about Mr. Jackson's case or Mr. Stillwell's case than you did with the other 3 defendants, based on additional witness testimony, correct?
Well, I mean, I at least had some evidence that he committed the murder, yes.
Okay. All right, and just to be clear, in January 2016, when you're working on this case, and throughout your investigation, Shannon Stillwell is still presumed innocent in jail.
He was in jail for about 250 days, I believe, on the murder charge before he was transferred, I want to say, to the Department of Corrections on unrelated matter. Okay. But yes, he was in jail, yes.
And he didn't bond out on this case until, on the 2015 case, until October of 2018, isn't that true?
I recall, if I remember correctly, he was booked into the jail on October 23rd and made bond the next day, because he had obviously gotten a bond long before then because he had been in jail over 90 days on the murder.
Right, but he was in jail for 3 years.
On the murder?
Yeah.
No, I don't believe he was jailed for 3 years. I believe he was in jail for about 250 days on the murder.
Okay, well, we'll say 250 days. I mean, that's a substantial amount of time, correct?
Legally, it's subjective as to what's substantial.
Okay. Well, you wouldn't want an innocent man locked in jail for that long.
Objection, argumentative.
I stain this to form.
Thank you,
I
Judge.
stain it.
Okay. Are you an ethical prosecutor?
Yes.
And for the record, I believe Mr. Sprinkle is. Okay. If you felt that there was no case against Mr. Stillwell like you thought about the others, you would presumably have done something to get his release, correct?
Right. What I would have done is I would have told his defense attorneys that essentially there was no evidence, which is what I did with the other co-defendants. So.
Okay.
Right. But with Mr. Stillwell, the absence of evidence wasn't quite as stark.
Okay. And so you didn't take any proactive steps to seek the release of Mr. Stillwell like you did the others?
No.
Okay. How long has, to your knowledge, are you familiar with the internal workings of the Fulton County District Attorney's Office?
Pretty familiar. I've been working there for over a decade, so.
How long has the Fulton County District Attorney's Office been investigating YSL? I can't speak to what the gang unit was doing at around this time. They were in a section of the office to which I didn't have access. Now, if I knocked on the door, if they were there, they would generally let me in, but I didn't just have
I didn't just have unfettered access to their area such that I could wander in at any given point. So they were, by design, closed off from the rest of the office.
Well, certainly you were aware generally of whether there was as you were working this Donovan Thomas case, whether there was an active investigation into YSL.
Yes, there was. And so to answer your question, to the best of my knowledge, as far as I knew, or as far as I can remember, the investigation into YSL really started with the murder of Donovan Thomas.
Okay, so 2015. And what about investigations into Jeffery Williams?
Objection, Your Honor. Relevant?
I'm alleging that this has been a strategic decision to withhold the prosecution of Shannon Stillwell, who they claim to have had a case with or against, a solid case against, since 2015. And I want to know why they waited 8 years to bring this case.
Well, then why don't you ask him?
Well, I want to know what investigation.
I'll overrule the objection. Go ahead and ask him, please.
To your knowledge, how long have you had an investigation ongoing, when I say you, the Fulton County District Attorney's Office, against Jeffery Williams?
For me personally, it would have been around, I want to say April of 2016 when I found out that he rented the car that was utilized in the drive-by shooting.
Okay. What about, not you personally, the Fulton County District Attorney's Office?
That I can't answer. As far as I know, I don't know. I have no idea. If there were any other investigations regarding Mr. Jeffery Williams, I don't know about them.
Well, could you answer if you knew, do you believe that you were the first person to begin an investigation into Jeffery Williams, or do you believe that there was already investigations into Jeffery Williams?
Objection, Your Honor. Relevance into investigations regarding Jeffery Williams.
I'll sustain the objection.
Thank you, Your Honor.
Did you have discussions with Paul Howard about the Donovan Thomas case?
Yes.
How often?
Well, there would obviously, every few months, actually. Maybe there were times it would actually be more often than that. It was definitely not one or two. I can tell you that. It was more than that.
Was he familiar with the facts of the case as alleged?
Yes.
Would Mr. Paul Howard have had access to the gang unit of the District Attorney's Office that you did not have unfettered access to?
I would presume yes. I guess I never asked him, nor did he ever tell me. It never came up, but given that he was the head of the entire office, I would assume that he had access to every room of the office. But I'm only assuming.
Do leaders of different units within the office meet with each other?
Yes, yes.
Is there coordination between units in the District Attorney's Office?
Yes, of course.
Was there coordinations between units back in 2015?
Yes.
Could there have been discussions that you were not privy to about these matters?
I'm sure.
Okay. Mr. Sprinkle, you have, is it fair to say that you largely have an investigative function within the District Attorney's Office?
Yes, for the most part.
But you all are also an attorney.
I am.
You have a bar card.
I do.
You're familiar with the laws of, the rules of evidence in Georgia?
Yes.
Okay. You would agree that we're in here today not on a murder case, but a large RICO case, which one part of it has an alleged murder?
I am familiar with the indictment that is before the court, that is being litigated right now, and I am familiar that the primary or the first count or couple of counts is a RICO case. As far as I'm concerned, I was primarily, if not really exclusively, concerned with the murder of Donovan Thomas.
Correct. But you are aware that this indictment that we're all in here today involves more than just the 2015 shooting of Donovan Thomas.
I'm aware of that, yes.
Okay. And there are 4 people that you chose to charge and indict. Well, we'll get to that. There's 4 people that you advised the state to indict for the murder of Donovan Thomas.
Well, I believe there are 5, and I was definitely part of meetings regarding the indictment. But again, this is really Don Geary that was leading the charge on who to indict for the murder. Now, was I influential? Of course, okay. But I wasn't the one who ultimately made that decision. But
you weren't the one to make the decision. When was this case ready to take to the grand jury? The alleged murder of Donovan Thomas.
Well, it wasn't an alleged murder. He absolutely was murdered. It was May of 2022.
It wasn't ready?
No. When was the case presented to the grand jury?
When was it ready to take to the grand jury?
I can't, again, because Don Geary was the attorney that was working on that, and I wasn't. Well, I guess it was ready when we presented it, right? I would assume.
Well, that's when your office chose to present it.
Yes.
I'm asking when it was ready.
I don't. You would have to ask Don Geary that. Okay. Because as you said, this is more just the murder of Donovan Thomas. This is a big RICO case. So.
I'm aware of that, but I'm very interested in when the singular incident, the January 2015 shooting of Donovan Thomas, was ready to present to the grand jury.
I would just have to say May of 2022, unless you can define the word ready with a little more specificity.
That's when your office decided to present it, is your answer.
Right, correct.
Mr. Sharp, hold on one second.
You received credit for each of those days as to the unified defense for which you got 10 due 3, went off to prison, came back, bonded out next day. The only time he was only in there that I'm aware of. My information was.
He was also listed for this stuff.
I don't know if he was arrested. He was in jail for those things.
Okay.
So I wouldn't necessarily. I can argue the book and things I don't know which it is. I just received credit for every one of those days towards the sentence. Or those other crimes.
This right here.
He's also arrested for drug charges that had nothing to do with it. I don't have the separate drug charges. Off of that. No, I can't help you with that. I would just ask. Do what you can. No.
I'm not doing it.
All right, go ahead, sir. I'm sorry.
Thank you, Your Honor. May it please the court, once again. You're aware of the rules of evidence in Georgia?
Yes,
Okay, that dictate what is admissible at trial?
that's correct.
Okay. You are aware that the rules of evidence are different for a RICO case, correct?
That's correct.
You're aware that typically in a criminal case, quote unquote, bad character evidence is not admissible against a defendant.
With exceptions governed by 404B.
Right. And 404B, propensity evidence would not be admissible under 404B.
No, it's motive, intent, knowledge, plan or scheme, preparation, absence of mistake or opportunity.
You're aware of the fact that my client, Mr. Stillwell, because this is a RICO case, is being tried for 2 murders at the same time, correct?
I am familiar with the second murder from earlier this year, yes.
You're also aware that because this is a RICO case that was indicted in 2022, my client is accused of over a dozen overt acts that are listed in the indictment.
I am generally aware of the format of the indictment. I haven't studied it. If you're telling me that, then I'm sure that's true.
You would agree that oftentimes if people are simultaneously accused of 2 separate crimes, they receive different trials for different crimes, correct? Different allegations.
Well, it would depend on if it was, for example, a crime spree based, temporal proximity being very close to the incidents or almost considered one continuous incident, then you may indict them together. But particularly given the length of time between the 2 incidents, you would generally indict them separately, correct?
Okay, so, and you're aware that the other murder that is alleged against my client is from 2022?
Correct.
You would agree that that would not have temporal proximity, correct?
No, I would, no, if these were just 2 completely independent murders, I would not put the 2015 murder on the same indictment as the 2022 murder. They'd be 2 different murders under normal circumstances.
As a lawyer, can you see where that would be prejudicial against my client?
Well, yes, I suppose if you were to have 2 murders on the indictment, then the jury would be told initially that there was a finding of probable cause on not 1, but 2 different murders. And so I can understand that.
What about evidence being presented and discussed about the actions of other individuals for things that occurred years after 2015? Would those typically come in for a murder that happened in 2015?
Well, it would depend. If it was a gang-related murder, maybe. Because, when there's a gang charge that's placed on somebody, then there's a lot more evidence that can come in related to the street gang.
What about if your office decided to indict this 2015 incident in a timely manner and didn't wait till 2022? Would this case have already been tried?
Objection as to speculative and argumentative.
I sustain the objection.
Are you, through your investigation, did you come across a gentleman by the name of Termon Stillwell?
I did. Yeah, Detective Thorpe and I spoke with him, I believe, in early 2016.
Okay, and Termon Stillwell, who found Termon Stillwell?
I believe it was Detective Thorpe. It wasn't me, so it must have been Detective Thorpe. And I don't recall how he learned about Termon Stillwell.
Ever ask Detective Thorpe about the circumstances on how he found Termon Stillwell?
Objection, Your Honor, as to the relevance.
Yeah, what's the relevance, sir?
I mean, this is the investigation we've been talking
Hold on,
about.
Mr. Sprinkle,
This is the investigation we've been talking about that we admitted this report as part of, and I'm asking about the investigation. I'm cross-examining the investigation.
I'll rule the objection. Go ahead, Mr. Sprinkle.
Thank you, Your Honor.
Go ahead and answer that.
So if I remember correctly, he was in the Fulton County Jail. Well, we interviewed him at APD, but he was brought over from the Fulton County Jail. Contemporaneous with his arrest, he told, and from what I remember, he definitely told somebody with the Atlanta Police Department that he had information on the murder. And if I remember correctly, it was the members of the Apex unit. They may have been the ones that arrested him. But at any rate, he said something to some police officer that he knew something about the murder. That got back to Detective Thorpe, so Detective Thorpe told me about it, and then Detective Thorpe transported him from the Fulton County Jail to APD where we interviewed.
Did you ever talk to the member of the Apex unit to confirm that they were the ones that had first contact with Tremont Stillwell?
I don't recall.
And Tremont Stillwell, he was in jail for what?
Family violence battery, I believe.
Okay. Felony?
I don't remember if he was a recidivist or not. It may have been. I just don't remember.
And who was he accused of battering, beating?
I think it was his wife, if I remember correctly.
What's her name?
That I don't recall.
Would it be Vanetta Guffey?
That's it.
Okay. And so Mr. Stillwell, Tremont Stillwell, let me be clear. Tremont Stillwell came to your attention, and did you have an opportunity to speak with Mr. Stillwell?
I did.
And when was this?
March 22nd, 2016.
So we're still back in 2016.
We are.
Okay. And did Mr. Tremont Stillwell claim to know my client Shannon Stillwell?
Yes, I believe he said that they were relatives. They were related. Like it was Mr. Stillwell, Tremont Stillwell, said that he was his cousin, if I remember correctly.
Did you ever confirm that there was any family relation?
Well, apart from their last name being the same, or one of Mr. Stillwell's, Shannon Stillwell's last names, because he was known as either Jackson or Stillwell. I mean, even back in 2016, I knew that was one of his aliases. I was never completely clear as to which name was actually his name, Shannon Jackson or Shannon Stillwell.
Okay, but let's just benefit of the doubt, it's Shannon Stillwell. Did you ever independently, other than they had the same last name, confirm that there was any relation between the two?
I don't remember.
But Tremont Stillwell claimed that he was Shannon's uncle.
I thought it was cousin.
Cousin, okay.
Yes.
Cousin. And Tremont Stillwell was in jail at the time that he met with you guys, correct? I know that you brought him over to APD headquarters, but he had pending charges.
That is correct.
Okay. And he gave you some information he claimed could be used against Shannon Stillwell.
That is correct.
Okay. And he claimed that back in 2015, Shannon Stillwell ran up to him while he was walking with his wife in the park.
That is correct.
Did he indicate which park?
I don't recall the park. I just recall it being August, or it was sometime during the fall of 2015 that Tremont Stillwell, as he strolled through the park with his wife, Miss Guffey, he came upon Shannon Stillwell, who complained of getting shot at some point in the very recent past, and that the reason for this was that he had participated in the murder of Donovan Thomas.
Okay, and according to Mr. Stillwell, according to Tremont Stillwell, Shannon Stillwell said that Kenneth Copeland, the state's witness, was also involved.
That I don't. Yeah, actually, I think he did say that. Now that you mentioned it. Yes.
Okay. And if Tremont Stillwell was to be believed, that would be a confession coming out of Shannon Stillwell's mouth.
A third-party confession, yes, sir.
Okay. And of course, as we saw with Mr. Wright, Mr. Stillwell, Tremont Stillwell, had pending charges at this time.
He did.
And as an investigator, you wanted to corroborate what Termon Stillwell was claiming that he had witnessed.
That's correct.
And you were also aware that there were many street rumors going around at that time.
There were, yes.
Okay. So you sought to corroborate the statement of Termon Stillwell.
That is correct.
And you decided to call in Miss Vanetta Guffey to talk to her about the situation, correct?
That is correct.
Okay. And speaking of Vanetta Guffey was important because she was the person that Termon Stillwell claimed was his wife.
That's correct.
And that Termon Stillwell was claimed was present when Shannon Stillwell supposedly made this statement, correct?
That is correct.
Okay. And you were able to speak with Miss Vanetta Guffey, correct?
Yes, I believe, I definitely remember speaking with some female after that Termon Stillwell interview, and it was related to that interview, and it didn't go very well.
Okay, now, Mr. Sprinkle, I want you to know that I have no objection, of course, subject to the judge's rulings, to you referring to your notes to answer these questions.
I'm actually referring to the Exhibit 11.
Your report.
Right.
Right, and I have no objection to that at all. I want, so we're clear on this. What page are you on?
Oh, well, the pages aren't numbered, but I'm on the page that starts with on May 11, 2016. Oh, well, it just so happens I'm on the right page.
All right, cool.
All right, so it was on May 11, 2016 when Detective Thorpe and I interviewed Vanetta Guffey on the 7th floor of my office, the DA's office.
Okay. And you said it was you and who that interviewed her?
Detective Thorpe, Jim Thorpe Jr. with the Atlanta Police Department.
And how did you get Miss Guffey to come to your office?
I don't recall. I believe if I had to, hold on, let me see.
Did you tell her it was about Termon Stillwell's case about him beating her?
I believe so. That sounds right.
Okay, so is it, and I'm not suggesting it's illegal for you to do this, but you misled her about why you wanted to speak.
Well, I mean, as a practical matter, I mean, that it was a legitimate area of inquiry as well. She was a victim on a case, but, you know, we didn't want to tell her about the murder, because she didn't even know that she was part of the murder investigation yet. So to get her into the office, we thought it would be better to just not tell her about that part, and rather just tell her about the case in which she already knew she was a witness.
Okay, fair enough. And you eventually told her you wanted to speak to her about this case.
That's correct.
And did you tell her that Termon had said that she may have witnessed something?
I did.
Do you remember exactly how you worded it? I shouldn't say exactly. Can you paraphrase how you worded it if you don't remember exactly?
I asked her about Shannon and asked her if she knew of Shannon. She said that she did, that she considered him her little nephew. And she also said she wasn't fond of Termon Stillwell because, going back to the case in which she was a victim, because of him beating on her. At the time of the interview, Mr. Termon Stillwell was still in the Fulton County Jail. All I remember is that when we brought up Shannon, her mood, she was relatively pleasant at the beginning of the interview. And, you know, after we discussed the battery and moved on to Shannon, she was, her mood changed. Shannon Stillwell, your client, her mood changed rather dramatically. In fact, it culminated in her storming out of the room and basically running out of the office.
Right. And she made it clear to you that you shouldn't believe a word that Termon Stillwell says.
She called him a liar.
Right.
As she stormed out, I believe she called him a liar.
He's unreliable.
Right. That's what she said.
And you don't dispute that Ms. Guffey knows Mr. Terman Stillwell very well.
No, she knew him pretty well. I mean, she was a victim on a family violence battery case, so you have to know somebody pretty well to be considered a victim of a family violence offense.
Okay.
Mr. Sharp, before you pose your next question, how much longer do you think you'll have?
I was about to ask like 3 more questions.
Oh.
Unlike Mr. Menendez, I think I'm being...
Who's 2 is not really 2?
Right.
Okay, all right. Okay, well, I'll be the judge of that, okay? This is number 1 coming up right here, okay?
Pressure on. Mr. Sprinkle, did Ms. Guffey indicate to you that she was not... Did she ever indicate to you that she had heard Shannon Stillwell say anything about a murder?
No. Without even refreshing my recollection, I mean, the interview ended pretty abruptly after she realized that we were asking about Shannon Stillwell. It wouldn't have even got... She was no longer participating in the interview, essentially. Towards the end, I was trying to ask her questions as she ran away from me, so...
She told you that she doesn't know anything about the statement that Shannon Stillwell allegedly made to Terman Stillwell.
That's correct.
That Terman Stillwell claimed that she witnessed.
That's correct.
Okay. Are you aware of where Ms. Vanetta Guffey is now?
Well, I've been told, and this I haven't independently verified it, but as of yesterday, it's my understanding she's deceased.
Okay.
She didn't die yesterday. I learned about it yesterday.
Right. I beg the court's indulgence, just briefly. Mr. Sprinkle, you, as part of your investigations, do you stay abreast to what's going on at 901 Rice Street?
Well, yes, particularly with respect to the jail calls.
Okay. Are you aware that there have been multiple attacks on my client, Shannon Stillwell, since, and when I say attacks, stabbings, he's been incarcerated this year?
This year?
Yes.
No, I wasn't aware of that.
Are you aware of multiple attacks on Shannon Stillwell while he's been incarcerated?
Objection, Your Honor, as to relevance, as to whether or not the defendant has been attacked.
He's been incarcerated for a long time, and it's certainly relevant that he's being attacked.
I'll overrule the objection.
I remember a time in late 2015, which would have been around the time he was arrested. He was actually a witness on a murder case. And he was in the same area of the jail as some rival gang members. That's about all, and that there was an issue with that, but that's about all I remember. I don't remember anything about him being attacked.
Are you aware that he's on 23-hour lockdown for his own safety at this time?
No, I didn't know about that.
I don't have anything else, Your Honor. Thank you. Thank you, Mr. Sprinkle.
All right, Madam, Ms. Love.
Thank you, Judge.
It's about 1:30. Can we take a comfort lunch lunch break to 2:15, and then we'll resume at that point in time, okay?
Thank you, Your Honor.
All right. We're going to be recessed until 2:15, and we'll come back at that point in time.
Why you? Okay, man.
You get you ain't hear them folk outside.
You know what they were saying?
And Your Honor, should anybody else ask questions, we wait after the redirect or before?
Judge.
For real? Let me let her finish, and then I'll let you all cross as you see fit. Let her redirect, okay?
Thank you, Your Honor.
All right, no problem. All right,
Thank you, Your Honor.
go ahead, ma'am.
Deputy Sprinkle, on cross-examination, you were asked specifically about attempts to delay this case to gain a tactical advantage. Were you ever instructed to delay this case in any way to gain a tactical advantage?
No, not at all.
You were also asked on cross-examination about the date that the defendant, Shannon Stillwell, was arrested for the homicide or the murder of Donovan Thomas. At the time that the defendant was arrested, on October the 27th, 2015, was the defendant also arrested for July 15th, 2015, possession of a firearm during the commission of a felony, criminal use of a firearm with an altered identification mark, and possession?
I'll sustain this to form. Go ahead and just reform the question, madam.
At the time that the defendant was arrested for the murder of Donovan Thomas, was the defendant arrested for other charges as well?
Yes, it was not just the murder for which he was arrested in October of 2015.
And while in jail on those other charges, did the defendant enter a plea on those other charges?
Well, I don't know exactly what happened. I know that he was convicted of those other charges and sent to the Georgia Department of Corrections. I believe he entered a plea.
Fair enough. And so during the time that the defendant was initially in jail for the murder of Donovan Thomas, he was convicted, is that what you're saying, of charges unrelated to Donovan Thomas?
That's what I'm saying, yes.
And was he then sent to the Georgia Department of Corrections or prison as a result of that conviction?
Yes, approximately, this is not the exact, 250-something days after his incarceration on October 27, 2015, he was sent to the Georgia Department of Corrections.
And was the defendant given credit on his sentence for those unrelated charges to the Donovan Thomas murder for those 200 and some odd days that he spent in the Fulton County Jail?
Are you asking, did he get credit for time served?
Yes.
I mean, I can presume, but without the actual sentence, I can't say for sure.
Okay. Just one moment, Your Honor. And Your Honor, I would ask that the court take note of the final defendant disposition filed in case 15SC140132. Take judicial notice of that, as it is a part of the clerk's record in Odyssey, as well as the affidavit of the custodian in that same case, 15SC140132, filed April 12, 2016, as well as jail booking for booking number 1521859. Deputy Sprinkle, after the defendant's prison sentence, Fulton County Jail on or about October the 23rd of 2018.
He was, and then he bonded out the next day.
And was that one full day that the defendant spent in jail from October 24, 2018 from October the 23rd, 2018 to October the 24th of 2018, the one day that the defendant spent in jail for no reason other than the murder of Donovan Thomas.
Yes, that sounds correct. And I don't know if it was 24 hours or if it was 8 hours or 3 hours. It was within a day he was released.
You were after you spoke with Vanetta Guffey. Do you recall being asked about that on cross-examination?
I recall being asked about Miss Vanetta Guffey.
Okay. During your conversation with Vanetta Guffey, you were asked on cross-examination whether she explained, whether you all told her, rather, that you wanted to speak with her regarding a domestic violence incident. Do you recall that?
That's right. She was the listed victim on a domestic violence, family violence battery case with, I believe it was her husband, Tremont Stillwell.
And during the conversation that you all had with Ms. Guffey, in the time that you sat down with her, did Detective Thorpe ask her if she is familiar with the defendant?
Either he did or I did, yes.
And did she acknowledge that she was familiar with him?
Yes, she said that he was, I believe I'm quoting directly or exactly, like her little nephew.
And did Detective Thorpe pull out a photographic lineup containing an image of the defendant and begin to read a lineup admonition?
She did, or he did, yes he did.
What did Ms. Guffey respond, or how did she respond near the end of that recitation of the lineup admonition?
Well, I mean, I can quote her. She said, but what is this in regard to with Shannon? Before we can start anything, if this isn't dealing with my ex-husband, I don't even want to be here because I don't deal with Shannon like that. Okay. So she cut him off.
And did Detective Thorpe tell Ms. Guffey that Tremont Stillwell had said she was present when...
I still missed the form.
Did Detective Thorpe respond with anything in particular after Ms. Guffey made that comment?
Yes, he said that Tremont Stillwell, her ex-husband, told both he and I that she was present when Mr. Shannon Stillwell, or Shannon Jackson, confessed to, quote-unquote, a crime.
Prior to that point, did you or Detective Thorpe mention that the crime, or suggest that the crime was a murder?
I don't believe so. I mean, I audio recorded the interview, and just looking at my notes, which is a summary of the interview, I just characterized and I quoted Detective Thorpe directly when he said a crime. So going by that and my recollection, I would say no.
And was it at that point that Ms. Guffey ended the conversation?
Well, yeah, she scoffed at at Detective Thorpe's assertion that Tremont Stillwell, her ex-husband, had said that she was present while Shannon Stillwell confessed to a crime. She said that she wasn't around him like that, essentially, and then she said he was a liar, and I think it was around that time she...
He's a liar.
That'd be Tremont Stillwell.
Okay, all right, thank you.
And did Ms. Guffey indicate that Tremont Stillwell did not deal with Shannon Stillwell?
Now you're leading.
Well, I know...
What did Ms. Guffey then say about Mr. Stillwell, that is Tremont Stillwell's relationship with Shannon Stillwell.
Okay, I'll just quote her directly. She said, Tremont Stillwell is a fucking liar and I'm ready to leave. So that's a lie. He don't even deal with him. I told him that was his cousin. He don't even deal with him. And then she went on to say, whatever Shannon did, that's on Shannon. I don't have anything to do with that. Thank you.
What did she then do?
She got up and Hurley walked out of the room. We followed her, Detective Thorpe and I did. I continued to audio record my interaction. She uttered something that I wasn't able to understand, but it ended with nothing about a homicide. She just...
Do you think that that was significant?
I thought it was somewhat significant because we hadn't said anything about a homicide.
And did you hear any more utterings by Ms. Guffey as she neared the elevator?
Yes, I followed her outside. She called someone on her phone and she said, quote, girl, come get me out from down here. They're talking about a homicide. And
at that point, had either you or Detective Thorpe mentioned anything about a homicide?
no.
And did you hear Ms. Guffey tell the called party anything else about Shannon Stillwell?
Well, just as the elevator door closed, she said that the questioning concerning this homicide dealt with quote unquote Shannon, and that she quote didn't deal with Shannon like that, end quote.
And did you capture the entirety of that interaction on your pocket voice recorder
I did.
and make it a part of your investigative case file?
Yes.
Why is it that you're not mentioning anything about a homicide made Ms. Guffey's words significant to you?
Well, we hadn't told her about what kind.
I sustain the objection. I think he's already mentioned it anyways. It was significant. It was significant because of he didn't say anything about the homicide investigations.
Thank you, Your Honor. One more moment, if you will, please.
While you're doing that, Mr.
Thank you, Your Honor. That's all that I have. Thank you.
All right.
Mr. Sprinkle.
Yes.
Hey. 88 Love was just asking you about Vanetta Guffey mentioning a homicide, correct?
Yes, that's correct.
And she's making a point that you never mentioned homicide?
That's correct.
Okay. Now, we're aware that there were many street rumors going around at that time?
Yes, from my review of, for example, Instagram at around that time, certainly there were many. I don't think it's a mystery that there were a lot of rumors going around about concerning the murder at that time.
And so there could have been many ways that Vanetta Guffey could associate Shannon Stillwell with a quote homicide?
Yes, it wasn't a top secret government secret, so to speak.
Mr. Sprinkle, how would you suggest we get inside Miss Guffey's head and figure out how she knew about homicide?
Well, clearly we wouldn't be able to do something like that. The technology doesn't allow for it.
Well, what would we do?
Calls for speculation. The question, form of the question.
Can we, well, when you want to know what's going on in someone's head, is there a way that you could inquire?
Well, yes, you could ask them, but of course, Miss Guffey, we can't ask now because she is deceased.
Oh, so what we're talking about, we can't inquire about what was going on in Miss Guffey's source of knowledge because she's unavailable now.
She is unavailable now, and based on my interaction with her, I don't believe she was interested in answering any more of my questions at any rate. But now it's, of course, an impossibility because she's dead.
And she's unavailable to the defense as well.
I'm sorry?
She's unavailable to the defense as well.
She's unavailable to everyone, assuming that my information is correct, that she is in fact deceased. That's what I was told yesterday.
Okay, and she passed during the pendency. I know you don't know the exact date, and that will be tendered into evidence, but she passed during the pendency of this case, is your understanding?
If she died between the date that I interviewed her and today, then that would be during the pendency of the case.
Okay. One more thing. You asked if anyone instructed you not to indict the case to gain a tactical advantage, correct?
That's right. Yeah, that was never ever part of our conversation.
But again, you're not the one who decides when to indict the case, correct?
No, I'm not.
Okay. All right. Thank you.
All right. Mr. Jimenez? Cross?
Thank you.
Your Honor, as the person who's going to make the legal argument, may I make a short argument to the court?
Sure.
This is the defendant Stillwell's motion for constitutional speedy. That is his personal right. Now, the evidence that will be introduced at trial will be introduced against all of them unless there's limiting instruction because of the RICO count. However, the issue on whether one individual's constitutional speedy rights were violated is specific to him and does not apply to anyone else. And so there's no motion currently before for which any cross-examination by any other particular defendant's attorney would be at all relevant, and there'd be basically this is testimony that is relevant to his and his motion only, Mr. Stillwell's. And so we would object to having anybody else cross-examine Mr. Sprinkle only because it is not relevant to the issue that is before the court.
Okay. All right. Thank you, sir. Go ahead.
Thank you, Your Honor. Good afternoon, Mr. Sprinkle. How are you?
Very well. How are you?
Sudi Chakaminez on behalf of Mr. Dorsey. I just want to go through this as quickly as possible. I know everybody has things to do. Let's focus on the timeline. I'm interested in the timeline. When did the murder happen?
January 10th, 2015.
All right, so in 2015, that's when the investigation happens. And then when is Stillwell arrested?
October 27th, 2015, if I remember correctly. It was definitely towards the end of October 2015.
When did you get a chance to talk to Mr. Wright?
That would have been January of 2016. Matter of fact, I believe I can actually give you them, refreshing my recollection. It'd be January 12th, 2016.
And Mr. Wright had been arrested and taken to the Atlanta City Jail, is that right?
He'd been sitting in the Atlanta City Jail since October 2015. That's correct.
Now, he was in the city jail on misdemeanor or felony charges?
I believe it was felony charges, a felony probation violation warrant, perhaps. He also had that gun. Maybe he was charged with that. But his charges were it was within the jurisdiction of the Superior Court.
Okay. And do you remember, is it accurate to say that when he was arrested, he actually did not see a judge within 72 hours? Do you remember that?
Objection, Your Honor. As to
Now we're going to
Okay.
I'll
move on to yours. You testified during direct that you had a chance to listen to a call by Mr. Wright. Is that right?
I did, yeah. That was the jail call that he placed to his friend shortly after his arrest. Jaquise Smalls is actually the friend's name. I didn't remember it on during Mr. Shart's cross-examination, but that's who it was.
And after you heard that call, did you know that it was him? Did you recognize his voice when you heard that call?
Mr. Wright's?
Yes.
Well, at that point, I had interviewed him, so I was familiar with his voice. This is going back a little bit. I'm going to go ahead and say I must have recognized his voice.
Is it fair to say you recognized his voice because you had interviewed him in person before?
Yes.
Your Honor, I'm going to object as to the relevance.
Yeah, what's the relevance there, sir?
We're trying to see if that is.
Does it have anything to do with your client, though? Because remember, even though statements, I'll give you a wide latitude if you're trying to cross as to statements that might be attributable or relevant to your client.
Yes, Your Honor.
Let's kind of focus and narrow it.
I'll move along.
All right.
Thank you, Your Honor. After you spoke with him, then you wanted to verify that whatever he was saying was true. Is that right?
Well, if we're speaking about Mr. Wright, I was verifying that what he had said previously to the police was actually not true, and I was trying to confirm that this person had essentially made everything up.
Okay. And you had access to the video?
I did.
And then when you watched the video, whatever this person claims that happened, whatever Mr. Wright claims that he saw, it would have been impossible because he's not seen on the video. Is that right?
That's right. He said he was at the bus stop. I believe he said he was standing there listening to an iPod or something to that effect. And he was very specific. But then when I showed him the video, I said, There's nobody standing there, and he didn't have a satisfactory explanation.
Once more, Mr. Dorsey is not charged.
I sustain the objection.
All of these interactions were happening around 2016, correct?
Yes.
You testified a little bit about how there's been changes in leadership at the office, is that right?
That's correct.
There's been at least 3 other people that were heads of the gang unit since this happened, is that right?
That sounds about right. Yeah, it was Adrian Love, Kara Convery, yeah, and then Chris Sperry was the current head of the gang unit. Gabe Banks was the head of the gang unit when all this happened back in 2015.
Ultimately, can you tell us with some degree of certainty at what time did you determine you had enough evidence to go forward on this count and include it on the RICO count for Mr. Stilwell as well as his co-defendants?
What time did I independently figure that out?
Yes, what time did you?
Well, I think that around the end of 2018, we could have pursued an indictment.
Okay.
Not against Antonio Sledge, Kenneth Copeland, Demikian Garlington, but against the people that are currently charged with the murder. But I know that a lot was done after that, particularly in 2021. There was a wiretap, et cetera. And I also know that there's a difference between probable cause and beyond a reasonable doubt. So probable cause, of course, is the standard that we would need to secure an indictment. So if I'm being honest, which I must be as I'm on the stand, I would say by November of 2018, we had enough evidence to pursue a murder indictment. For probable cause, we had probable cause, I should say, not necessarily that we had enough to get a conviction. Okay. We could have obtained an indictment.
No, let some other people, okay, at this point, okay? All right, anybody else?
Thank you, Your Honor.
Okay. Just wait, Mr. Sharp. Okay, anybody else? Going once, going one. Mr. Sharp, how about it?
Mr. Sprinkle, when you said November 2018, you were speaking about all 5 charged individuals, correct?
Yes, we would have had, I think we would have had probable cause in November of 2018.
And you would agree that probable cause against Mr. Stilwell individually existed well before that date?
We could, well, and okay, so to your question, January 2016, what did we have? We had Quindarius Zachary's third-party confession against him. That's really about all we had in January 2016, and he was a co-conspirator, fellow gang member. I would be, I don't know what the grand jury would have done if we had presented that. If we had presented that evidence to them, certainly there was some evidence that third-party confession.
We also had Kenneth Copeland's statement to Investigator Gaither and Dennis. Obtained this evidence from Termon Stilwell.
That would have been after January 2016, but yes, I did.
But that would have been before November. When?
That was March of 2016, the interview with Termon Stilwell.
2020 person claiming that you could have taken as the.
Yes.
Thank you.
All right, anything further, madam?
No, Your Honor, thank you.
All right. May Mr. Sprinkle be permanently temporarily excused at this point in time for purposes of this motion?
Yes, Judge, thank you very
All
much.
right, Mr. Sprinkle, sir, I'm going to go ahead and excuse you as a witness at this point in time. Don't discuss your testimony with anybody except your changed in this case, okay?
Yes, Your Honor.
All right, thank you, sir. All right, argument.
Your Honor, I just have a couple of documents to admit to evidence.
Okay, all right. Let me do this correctly. State have anything further in regards to evidence on this particular motion?
No, Your Honor.
Okay, motion is dismissed. All right, okay.
In Your Honor, I'm sure you can say Defense Exhibit 1 is a certified death certificate of Benedict Guffey, who passed on 7/14/2021.
Okay. Any objections to D1?
No, Your Honor.
All right, D1's admitted.
I have D2, which I guess I could ask that you take judicial notice of, but it's I've marked it as D2. It's a motion for constitutional speedy trial filed on behalf of Mr. Shannon Jackson, aka Shannon Stillwell, under the unindicted case number for this case, 15 CP 155953, dated July 2nd, 2019. And it is in Odyssey.
All right. Any objection to the court taking judicial notice of that?
No, Your Honor, I was going to bring this to the court's attention.
Okay, all right.
And
Then D2 is admitted.
And I'll also.
Well, I will consider it for purposes of the motion. Anything else?
Yes, Your Honor. I would ask that you just do as you did with the state.
I'm sorry, one more time?
I'm sorry.
You got to speak in the microphone so
Yes.
everybody can hear you.
Yes. I would ask that you take into judicial notice, as you did for the state, to the fact that in this case, 2 additional constitutional speedies have been filed for Mr. Stillwell, one on May 9th of 2022 under this indictment number, and one on August 5th, 2022 on September 30th, 2022, the constitutional speedy was filed, excuse me for that, and then an amended constitutional speedy was filed as well, Your Honor.
I'll take judicial notice of those two.
And I would also ask Your Honor to take judicial notice of the standing order from Judge Brasher and also the Supreme Court of Georgia that no statutory speedies have any effect until January 1st of 2023.
Okay. Do you have copies of those that you'd like to add for purposes of the record?
I can supplement the record if Your Honor will allow me. I don't have those printed out at this exact moment.
All right. I'll take judicial notice of the standing order issued by the former Chief Judge Christopher S. Brasher, as well as the standing order issued by our Supreme Court of Georgia in regards to speedy trial demands and tolling thereof. Okay. Anything else?
As far as evidence, no.
Okay. All right. Argument?
I do have argument.
Go ahead.
If I'm the movement. I'm the movement.
Yes, you are.
I would waive my opening if I'm allowed to give a closing after the state argument.
Well, it doesn't kind of work that way on this particular issue.
Okay.
You need to go ahead and walk through those particular factors that that in terms of okay, so we're dealing with the bar. I mean, just to give you kind of like a framework, and you certainly are very experienced as to this. One second. Young man in the back over there in the tie, could you please get rid of your gum? No, you're turning around. Yeah, get rid of your gum. Don't swallow it and bring personal injury to yourself, okay? And don't stick it underneath my seats, all right? Mr. Harvey, how come you didn't tell him that that was one of my verboten rules?
I was watching the space. Not paying attention.
Obviously, okay, all right. So under
Chewing tobacco.
so that's even worse. Under Barker versus Wingo, 407 U.S. 415, and in the dogged, there are 4 factors that I have to consider, okay, in deciding this. Factor number 1 is the length of the delay. 2, the reasons for it. 3, the defendant's assertion of his right to a speedy trial. And 4, the prejudice to the defendant. And, of course, I have to go ahead and look at that. And the threshold, of course, issue is, from a constitutional speedy trial demand, is the interval from the arrest, indictment, or other formal accusation to trial. And we haven't gotten to trial, but we are going to trial on the 9th of January of 2023, is considered to be presumptively prejudicial. So go ahead and start out with that. That's your roadmap.
Okay.
The state has responded. I'll let them go ahead and, of course, go ahead and make their argument. But go ahead and start off with the delay.
Would it be helpful to Your Honor, and I will follow your instructions, would it be helpful to provide a brief timeline of the key dates? Or is that clear to the court?
it's clear to me. I mean, to the extent that you need to be able to show me. So, I mean, I think that if you need to establish when your client was arrested, when he was indicted, any other relevant dates for the purposes of establishing what the court and my determination of delay, what that delay is, and who that delay is attributable to, because that's, of course, I have to weigh that. And of course, factor number 2 requires me to look at, excuse me, I think your client, let me complete my thought to begin with. I apologize, sir. Factor number 2 is the reasons for it. 3, the defendant's assertion of his right. 4, prejudice to the defendant. So it looks like on or about the 27th of October, 2015, he got arrested for the murder of Donovan Thomas. And then apparently there was you can take it from there, okay, and then go ahead and give me your resuscitation as to how you believe that that you were that this delay, because that's the first thing I have to kind of consider.
Right. I would agree that October 27, 2015 starts the clock. Of course, it's the earliest of arrest or indictment.
And I need to decide whether or not it's presumptively prejudicial.
Yes.
So, and if I do, then if I don't, it fails. If I do, then I continue on from there.
Well, we are at 7 years and 2 months since the date of arrest. So the presumptively prejudicial threshold is often considered 1 year. So I believe that we are well past the presumptive prejudicial aspect of this, and I believe the state concedes that. And
no statute of limitations for homicide, though, right? Or alleged homicide, right?
Correct, but I would say that that's a completely different issue altogether. I mean, it is true that there's no statute of limitations on homicide, but and so if they had never arrested Shannon Stillwell on October 27th, 2015, I would have none of these arguments.
Okay,
but they started the clock with the arrest.
I think the state concedes that a delay approaching 1 year generally is going to be presumptively prejudicial.
Right.
So they've discussed with through Mr. Sprinkle that they had some investigatory issues that were going on at that point in time. They might have had enough to seek an indictment, but not a conviction. And, you know, in terms of the way that their case developed and the interrelated nature of the homicide and potentially some gang affiliation. So they've testified about that issue as to why it took so long. Because you're asserting, well, they did it for tactical advantage, and as a result, Miss Vanetta Guffey's dead. You can't call her as part of your witness. That's prejudicial to you. Is that right?
It's slightly more nuanced than that. I am not asserting Miss Guffey, in all candor to the court, you'll see it in the death certificate. She died of a brain aneurysm, and it was an unexpected death. I am not asserting that the state secretly knew that Miss Guffey was in bad health.
No, and I'm not saying that, but generally, whenever you have a witness on availability issue, then you've got to be able to establish that it would have made a difference anyways. What she would have tested, what you would have. But we don't. The challenge we have with that is indicated by the state, is that we don't know necessarily what she would have testified to, what the weight and value of her testimony would have been, if it was reliable or unreliable, whether or not they would have called her as a witness, whether or not that would have made a difference in your case. So to the extent that if you can address Ms. Guffey and tie that to something that you think that's prejudicial to your client.
I will. Would you like me to go straight to the fourth prong, or I mean, because they're all interrelated.
I know they're related, okay, but yeah. So is there anything else, the length of delay you want to call?
Yeah, well, there's a few things I'd like to.
Because then you can move on to cause of the delay.
Okay.
Okay.
All right. I would like to point out that Mr. Sprinkle, under oath, honestly testified that he does not control when to indict cases, but in his estimation and experience, they had enough to take Mr. Stillwell's case, Mr. Shannon Stillwell's case, to the grand jury in March of 2016. I am not concerned with any co-defendants. I am not concerned with the status of the case of anyone on this RICO count for the purpose of this argument.
Okay, but the state, and I'm hijacking because I want to have a conversation with you about it, is that they being the state has indicated to you and that they certainly probable cause, to get an indictment, but not beyond a reasonable doubt to convict. So they've told you the reason why they waited. You don't accept that particular explanation from them?
I don't think Mr. Sprinkle ever told us why he waited on Mr. Stillwell, because he doesn't know, because he wasn't the one that made that decision.
But he did testify that he said, in all honesty, because I'm an officer of the court, I'm required to be honest, we had enough for a probable cause for an indictment, not enough for to prove beyond a reasonable doubt, which is trial standard. So that's what I took his testimony to believe in terms of, sure, he could have sought an indictment in 18, but that's not, but ethically as a prosecutor, you don't want to necessarily indict and then search for evidence. That's not how it works. You have to have, certainly, you can certainly develop other evidence and whatever, but he's telling you that from the strength of the case that they had in 18, it wasn't enough.
Well, I don't think he said that about Mr. Stillwell.
I know he didn't say that, but that's what the court's going to extrapolate from his testimony.
Well, Your Honor, I'll back up a little bit. And the purpose of constitutional speedy is we're talking about they need time to develop. The purpose of constitutional speedy trials is they're supposed to develop before arresting someone in taking
arresting somebody.
Yeah, taking their liberty away. They're supposed to have a case. And the idea that they went and locked Mr. Stillwell up and now we're saying, oh, they didn't have enough to proceed on him, yet at the same time, no one from the DA's office said, hey, we don't have enough to proceed on him, so let's drop these charges.
But remember what Mr. Sprinkle said. At some point in time therein, it developed that this homicide may be interrelated with a RICO case. And that's why they decided to go ahead and further develop in that particular issue. So I'm going to weigh the delay factor slightly against the state. Okay, let's move on to number 2, the cause of the delay.
Your Honor, I would just like to say that I would just like to stress it was 7 years and 2 months, and that they did not seek an indictment until 2020.
And you know what? They are. I think that factor is going to weigh against the state, but it's only going to weigh against it slightly or benign. Okay.
And I'll also point out, Your Honor, that the case law and just regarding delay, just for the record, Your Honor, the presumption of pretrial the prejudice from pretrial delay intensifies and compounds over time. And there are cases in Georgia where delays less than this. State v. Sutton, 7 years delay was egregious according to the state, and it removed the need to show particularized prejudice, which we have here. But I would just like to stress to the court that the delay is not, before we move on to the next thing, and I am going to move on, that the delay is not an isolated factor, but it also affects the ability to show the other factors.
Sir, I agree with you.
Okay.
I agree with you because it does affect it bleeds into the second factor, and it bleeds into the third factor. So I understand, and don't disagree with you in the least. Okay.
So I'll move on to cause, and I think this is important because, Your Honor, in his analysis,
I got a question for you.
Yes.
Do you think the state deliberately tried to delay your case?
I think they made a decision. They made a tactical decision, and Your Honor, in just asking the last question.
Do you think that they deliberately delayed your case in order to hamper your defense? Because that's really the issue. Did they delay you to hamper your defense?
Well, Your Honor, I'm going to cite the Hayes v. State.
Now, answer my question. Answer my question.
It's not,
did they delay your case in order to hamper it?
There's 3 levels. There's not just 2.
Well, answer my question. Did they delay your case in order to hamper it?
I don't believe that they deliberately acted in bad faith. But I do believe that there's a middle ground under Hayes v. State, 298 Georgia.
Okay, well, it's not negligence. They're not saying, well, hey, we had an overcrowded docket. He slipped through the cracks or anything such as that that's argued in many of these cases. So they've told you, you might not like it, but they've told you why it is that you, they had a protracted investigatory period, let's just say, on your case.
I would agree that there was a protracted investigatory period. I don't necessarily agree that all of that involved Shannon Stillwell. I believe that they had that case wrapped up in 2016.
Okay, so if I believe the state, which from their testimony, then that's certainly a reason that I could do it and it would justify that delay.
Well, I don't believe so. And
why not?
I'm going to explain why. Well, first of all, we haven't heard.
Well, under Barker versus Wingo, that is what I'm supposed to look at.
I agree, but Barker v. Wingo has been.
I mean, you have to show a deliberate attempt.
I don't agree.
To go ahead and.
Your Honor, I don't.
Do that.
Respectfully, I do not agree that I have to show a deliberate attempt. First of all, I don't believe I have to do so with such an extreme delay. But secondly, Your Honor, there is a middle ground.
Okay, but let me rephrase. They have told you why it is it took them a protracted period of time in this particular case. They've told you through Mr. Sprinkle, more than a proffer. He's put his hand up and he said, hey, listen, we had this homicide. We started to develop other information. There might have been retaliatory shootings in regards to this homicide. There might have been gang affiliation or gang activity related to that. And the interrelationship with those 2 aspects, as testified by Mr. Sprinkle, that would be a reason for them to justify the delay.
I respectfully, Your Honor, disagree.
Okay, we're going to have to disagree on that.
Well, and I'm going to say why. Because it was a decision. It was a decision they made that they wanted to put the 2015 case.
But what was the decision based on, sir?
Well, I will respond to that. First of all, Mr. Sprinkle made it clear he wasn't the one that made the decision, so we don't really know what the decision was based on, but it's clear to me.
Well, well, listen, from the testimony that's been given, this is the case that the state developed at that point in time. And whether or not they decided to pull the trigger and indict the case, which they told you they could have done it in 18, but they only have probable cause. They didn't have trial beyond a reasonable doubt, which is an ethical issue. Remember, Mr. Sprinkle says, I can't just indict something. I mean, that's why we get in this whole discussion all the time about ethical prosecution. Mr. Sprinkle had enough sense to tell you, hey, at that point in time, we're not indicting it because we don't have enough to be beyond a reasonable doubt. So
we're not indicting it. We just arrested him and had him in jail. And I mean, they are the ones that triggered it with the arrest. And the law requires them to pursue the charges once they make.
Do you think this is a complex case or a simple case?
I think it's a very simple case that they have chosen to make complex.
It's pretty complex.
Well,
you got 28 folks.
That's exactly my point.
You got a 65-page indictment. You have over, I think it is, how many counts do you have, Ms. Love, now?
65 counts.
65 counts.
And that's exactly my point.
So I mean,
Your
it's
Honor.
not simple. I mean, so if looking at Howard versus State, 307 Georgia Appeal 822, 2011. You know, you got an allegation by the state of continuing criminal enterprise. You've got the RICO issues. You got related. You got a homicide, and you've got a lot of acts that the state has to investigate. There's a lot of work with this case. So I'm gonna say to you that that this particular cause of the delay. Let's kind of, I don't believe that the court is of the opinion, based upon what I've heard in terms of testimony, that the state intentionally delayed this case to hamper your defense.
But, Your Honor, I just want to make clear for the record, my point is not that they intentionally did it to hamper my defense. They made a deliberate tactical decision on State v. Shirley, 311 Georgia Appeals 141 is the 2011 case. The state made a deliberate decision not to disclose the identity of a CI to the defense, which led to the lengthening of the time before trial. And what they say is gamesmanship is more than negligence. Hayes v. State, 298 Georgia Appeals 338. The state decided to dead docket a case and then call it back up years later.
Is that the case? Is that the case in this particular circumstance? Well, it's different in this case because they have continually tried to investigate it. So let's move on to your assertion of the rights for your trial. I'll agree with you. Your client asserted his right to trial on at least 3 different occasions. Would you disagree with that?
And I would just ask that you would note that really the most important one is the first date, which was in 2019.
What date was that, sir? I have the 9 May 22 and the 5 August 22. What?
I'm sorry.
Go ahead. July what?
July 2nd, 2019.
Okay, so he's at least asserted 3 times.
Correct.
So the court will go ahead and do that. But let me ask you this question here. Okay, so the incident date occurred in (2015), October 27th, 2015. So he waited some 4 years or thereabouts, almost 4 years. I'm terrible at math, but almost 4 years to ask for that particular trial to be or assertion of the right to trial. 3 years and some months.
Yeah, 3 years and some months. And it sounds like the state was making a point that he was in prison at that time. But, Your Honor, that case was unindicted. So he never had access to discovery. The case law says that failure to disclose discovering is a mitigating factor in a delay to assert your constitutional speedy trial rights, and I'm getting that from the...
When did they indict the case?
Well after he asserted...
As it relates to Mr. Stillwell?
They never indicted the murder by itself, and that's the whole point. It's a simple case that they made... Never indicted this murder case.
When did your client file a statutory demand for a speedy trial, or did he ever file one?
He's never had an opportunity to
Did he ever file one? No, that's the thing.
There's no...
Okay. All right.
Your Honor,
I agree.
On New Year's Eve at 12:01 a.m., after I kiss my wife under the mistletoe, I will file a statutory speedy demand, but there's no point in filing a motion, a demand that has no legal basis. In fact, lawyers are told not to do so. It's clear that there is no legal basis to file a statutory speedy trial demand at this time. If you want me to file one, I will.
I just want to make sure we understand one. Okay, you're good. You're good. Okay, so, all right, so,
But we've had these constitutional speedy demands in for...
all right, should I weigh that factor against the state or against your client?
Well, I think that it's neutral.
The state's asking me to weigh it against you.
Well, of course they are.
Because you didn't ask for, you didn't ask, your client never didn't assert the right to a speedy trial.
They wanted him to assert when he was in prison back in 2016, 2017, when I wanted them to indict the case. So, yeah, of course they want that, but again, it would be error of the court, respectfully, to fail to consider the mitigating factors of the failure to disclose discovery, and at State v. Buckner, 292 Georgia 390 at 397, that's 2013, and delay in indictment is a mitigating factor, and that's Hester v. State.
Okay.
And
what's the site on Hester?
I'm going to get it for you, Your Honor. I thought, yeah, I got it right here.
Does Hester talk about why the delay in indictment?
I can answer that in a second if I can get my notes. It was a vehicular homicide case. It was a 5-year delay. Well, more than 5 years. The defendant did not assert until after 5 years. And it was error for the court. The holding of this case was the trial court erred in denying constitutional speedy and dismissing the case. And the trial court erred in failing to consider mitigating factors such as delay in indictment, and also in that case, which admittedly does not apply here, the failure of the defendant to be appointed an attorney in a timely manner, which may apply to other people in this case, but.
Okay.
So that was the facts of Hester v. State, but I would also...
Well, you know, State cites Henderson, and they cite Johnson. Johnson is to invoke a right to speedy trial. The accused must assert it to the court, and then Henderson, that's it. Johnson's 291 Georgia, 863, pinpoint 866. And then Henderson is 310 Georgia, 231, pinpoint 237.
And in all respect to my colleagues at that table, I just, I'm not saying that this just came up today and they were working hard on it. They gave me their brief today, so I haven't really looked at those cases. But I will say in their brief, they're arguing that, again, an impossibility, and I can't even believe that they're making this argument that I have failed to file a statutory speedy trial demand, which I know we discussed. But, you know, quite honestly, I think that they're...
You can't file something that's not there, so...
Well, that's in their brief, so I'm skeptical.
And I'll be interested to see what Mr. Anderson, is it Mr. Smith? I'm sorry.
Armstrong.
Mr. Armstrong, I knew it was something.
14 years people have been calling me out.
Oh, gosh. Mr. Armstrong, I'll be interested to see what Mr. Armstrong says about that. But we'll, all right, so tell me about the prejudice. That's the,
well,
you argue oppressive pretrial incarceration and death of a witness. So,
well,
it's pretrial incarceration is presumed to be of harm to the defendant to begin with. So you can certainly.
I'm not going to focus on that, Your Honor.
Okay.
And so, but the point I would first make is actual prejudice, which I'm going to get to, that we do have in this case. But actual prejudice is not needed when the extraordinary length of delay raises a presumption of actual prejudice.
Okay, but I'm telling you,
after such a delay, the showing of actual prejudice is not needed, and that's Grizzard v. State, 301 Georgia Appeals 613, Redding v. State, 313 Georgia 730. That's a 2022 case. Hester v. State, which I've already cited. And the greater the pretrial delay simultaneously presumes and decreases the expectation that the defendant can demonstrate tangible prejudice to his or her ability to present a defense.
Okay, but here's the thing. the first thing is the state has given you a reason as to why the case took so long. So address from, and you keep going back to that issue, but I'm telling you, like you said, the factors are interrelated. I have to decide that to begin with. So address for me the, whether or not your client's been prejudiced.
Well, Ms. Love, in her redirect, made my point.
Made you what?
Made my point.
Okay, all right.
They have this witness, Tremont Stillwell, who says that my client gave a third-party confession in the park in front of Vanetta Guffey. I think we would all agree that a third-party confession is pretty substantial, important evidence. I don't think anyone would disagree on that. If they disagree on that, they can, choose not to enter any third-party confessions. So, Mr. Sprinkle, in following up, doing what he's supposed to do to investigate, brings in Ms. Guffey. Ms. Guffey, Mr. Sprinkle testified to this on cross. She said two things. Mr. Stillwell, meaning Tremont Stillwell, her husband, I believe it's actually like a common law husband thing, is a liar. That's one thing she said. And two, she denied being present at any conversation, any confession, anything involving Shannon Stillwell. Okay? She pushes back and becomes a defense witness that would impeach Tremont Stillwell. I think that's pretty clear. Somehow, and now she's no longer with us, sadly, and she's not available as a witness. Somehow, the prosecutors in this case, they just showed their hand. Somehow, her saying, I don't know anything about it, it never happened, and storming out, has become evidence that somehow she knew about this homicide and associates Shannon Stillwell with the homicide. And now we're speculating and inviting speculation from presumably the jurors at some point about all this stuff. And all I want to do, call Ms. Guffey to the stand. All they want to do is twist everything that happened in that room into the worst light possible to aid in their case, which they delayed in bringing, and which Ms. Guffey passed away tragically during their delay. And that is the exact problem. That's the exact problem. I want that live witness. Okay. And Your Honor, and well, I will say...
We don't know whether or not the state's going to call that Ticker Stillwell, and whether or not that's going to be relevant at that point in time. They also going to have it in the correct form to even have it admitted. So it's really dependent upon a lot of things that may or may not occur in this particular case. So,
and Your Honor, I will also, I don't think Your Honor disputes that the unavailability is in dispute here. I think that's obvious. I think the prejudice is obvious. The degree of prejudice...
But the state didn't cause the unavailability. You'd agree with that, right?
I don't think they literally killed Ms. Guffey.
She died of natural cause. She had an aneurysm. Is that correct? Okay, all right. Can you answer one more thing going back to the prejudice? Was your client jailed for anything during that particular period of time on unrelated charges?
I cannot. I defer to Department of Correction records on that. Are you speaking to the 254 days that were discussed?
Well, I'm talking about the period of time probably from 2016 to the time of the indictment. Was your client serving any other time in custody for any other offenses? I'm only asking for that because it makes a difference in the analysis.
I would defer to the Odyssey jail records on that. I think that there's likely periods of incarceration in all candor to the court. But, Your Honor, I would like to also point out that Hester case that I cited also makes it clear that the impact of a live witness testifying from the stand with the jury able to determine the witness's demeanor and credibility is what is important. And a transcript and a tape recording is not the same thing. We want to have the jurors be able to compare the demeanor and reliability and believability of Termon Stillwell versus Vanetta Guffey. And we have been denied that through this delay. You know, I know Your Honor's going to find out how Your Honor finds. But again, I would just...
But I gotta follow the factors, the four factors.
And I understand, Your Honor, but I just would like to stress, while I'm not saying that they knew she was going to die, what I am saying is they could have brought a very simple murder case against Mr. Stillwell many years ago, and they made the deliberate decision, the deliberate tactical decision to put it on this indictment with all these other individuals, with all these other overt acts, and with distinct rules of evidence that apply. So they did get it.
Isn't that their choice? I mean, they're the state. Isn't that their choice in terms of prosecution?
It is their choice, but it doesn't make it right.
It's not the way Max Shard would have prosecuted this case. If you were the district attorney, you would have probably prosecuted just like that, right?
I don't know what I would have done. That's why I'm not a DA, but, and I never will be. But,
all right.
But Your Honor,
I will
say though that they triggered this with the arrest, and then they decided to make this one incident a very complex, a part of a very complex case, and that was their deliberate decision. And they knew that my client had not only a right to a speedy trial, but had asserted his right to a speedy trial when they made this decision. And that's the problem.
Okay.
Thank you, Your Honor.
You're very welcome. All right, Mr. Armstrong, finally got your name right. Sorry, I apologize. Much as we've had contact over the past several years.
Absolutely, Your Honor.
It's been a long day, but go ahead, sir.
One thing I'm going to go in the order of the analysis, but one thing I wanted to begin with, because both the court and Mr. Shard assumed that I conceded a certain thing, but there's a nuance to it that I wanted to draw out for the court. Mr. Shard isn't simply attacking count 2. He's attacking count 2 and any count upon which is predicated on count 2. That's a coy way of referring to count 1.
Yes.
And so you have two different issues, and I submit to the court that those are two different speedy trial clocks, because the RICO conspiracy is the entire conspiracy, which extended into this year to include the murder of...
Count 2 is the dogged factor for four factors. What about count 1?
Count 1, we have not reached the threshold yet because the conspiracy bled into this year. And I've cited an Ohio case because there's no Georgia case that has decided the issue. But essentially, you go from the arrest or indictment for RICO, which happened this year, when you're dealing with the RICO conspiracy itself. And so because they're making claims against both count 2 and count 1 as something predicated on count 2, those are going to be separate analyses for the length of time.
Is that state versus Messer 207, Ohio, 5899? You cite that for that proposition?
Yes, Your Honor. Okay. And I would just like to be...
Speedy trial timetable for the RICO charge begins to run upon the date of the defendant's arrest for the RICO charge itself, not upon the dates of arrest for the predicate acts.
That is correct, Your Honor.
Okay.
And I'd just like to be clear that I did not select like the best case for me. I looked for the entire nation, and it doesn't seem that I could find any other case, any other court that had addressed that issue. This is the one court that I had that had addressed that issue.
All right.
And so I wanted to make that distinction that even if the court were to find something as far as count 2, it would not apply to count 1, and the case would still proceed with the information in count 2 against Mr. Stillwell. The length of the delay, the court has indicated that the court was going to hold that benignly against the state. I've made my arguments in the brief, and so I'll move on from that. The cause of the delay. You heard Mr. Sprinkle, Deputy DA Sprinkle testify here today, And that was the reason that we brought in his testimony, because Mr. Sharp did not make a specific allegation that the state had intentionally acted to gain a tactical advantage and hamper the defense.
Do you want to break down the time periods so to account for them?
Yes, Your Honor.
I think you've got 27 October 15 to 13 November 2018, and then you've got another period of 13 November 18 to May 9 22, and then May 9 22 to present.
Correct. So I divided those times this way for this reason, because Mr. Sprinkle had the large 140-page summary of the investigation as far as the case was concerned. That's a very, very large summary. That's not a summary that I've seen before, that length of it. That's the complexity of just the murders, I understand it. And so I wanted to draw that period of time because we have not just the live testimony, but his adoption of the more details that are in there to show the scope and what was going on in the investigation, shows the justifiableness of the investigation. From the period beyond that, we don't have a document to hand the court, but you heard Deputy DA Sprinkle testify about ongoing investigation, ongoing work with different prosecutors, and as the court noted, basically realizing that this was a large RICO conspiracy and trying to put all the pieces together and moving forward for that. I also want to mention that during that period of time was the COVID shutdown, which affected every part of the criminal justice system. And so I didn't want the court to, we have not been dealing with perfect normal times throughout this entire process. From May 9th, 2022 to the present, that was the date on which the original indictment came down, assuming that I have the correct date. From that point until now, everything has moved forward appropriately. There's been no unjustifiable delay. It's basically been a regular case. You've gone from May 2022, we are now in December 2022. That's 7 months and we're at the precipice of trial. That's a very, very quick turnaround. So I suggest to the court that that is an entirely appropriate delay that shouldn't be weighed against either party. But the main thrust of it, and I believe I heard you discussing with Mr. Sharp this, the state submits that it was a justifiable delay in dealing with the investigation for this case. The individual murder itself was complex to investigate, including original assertions that turned out to be false. And you have it being clear from the beginning that it was the precipitation for an ongoing set of violence between two rival gangs, and that ultimately became part of the RICO conspiracy. There is a case for the length of the delay that I cited that I think is also relevant for the cause of the delay, where I discussed there's a Georgia Court of Appeals case that had a 12-defendant RICO case that had a smaller number of predicates, where they said that that's the type of case that justifies a longer investigatory delay than a more simple event that doesn't have that conspiracy going on. Now, this will be, I did want to mention a few things about the third factor, which is the assertion of the right. I'm going to address an issue first that's a little bit more specific. I would normally begin more globally, but you were talking with Mr. Sharp about statutory speedy trial demands. That's not what I'm hanging my hat on. However, I interpret the rules, including Judge Brasher's statutorily approved pause of the statutory speedy trial demands, very differently than Mr. Sharp does. It is not something you can't file. It simply says the time the state has is paused until the January term of court for 2023. It doesn't say you can't file it. And I don't know who he's referring to who says you're not supposed to file it. I've not heard that. I'm not aware of anything of that. When I read the order, I fully expected the statutory speedy trial demands to keep on coming, just that they would not have their time towards the clock run as far as what the state has to do to meet them. And so Your Honor was interested in hearing what I had to say about those. That is one bit, because he couldn't file. Let me back up for a second. Mr. Sharp had made representations in the brief of what he could or could not do.
He could have filed it. It just wouldn't have been. It wouldn't have taken effect because the delay. I mean, the Judge Brasher's order and the Supreme Court of Georgia's order told those until January 1.
Correct.
So they would go live on January 2nd of the 2023.
Absolutely. And so the fact that he didn't file a statutory speedy trial demand is something that I just include based on the demands for trial that are made this year. One of the things that the court is going to be looking at is the vigor and the strength with which the assertion was made. And that leads me to the other issue, which is Mr. Shart mentioned in both of his motions to dismiss, the original one and the amended motion, that he could not have filed a formal demand for constitutional speedy trial without an indictment. That is absolutely false. You can do that the first day of your arrest if you want to. And in this case, that actually happened. And I submit to the court that since he filed on December 13th the amended motion, and given how it reads, where it asserts that he can't make a formal demand for speedy trial, and where he does not mention the 2019 assertion, I assert that if the defense doesn't even know they've made an assertion, it's not a strong one. The 2019 motion, it was not mentioned in his filings. It was not mentioned in Ms. Rosenwasser's original response to the court. And I found it last night. I had 3 copies to bring it, but it seems that Mr. Shart has found it in the past week to mention it. The document itself, I'd ask the court to look at the certificate of services off. It doesn't seem normal. And so we don't know exactly whether they filed it correct, what they did, because they just say this hypothetical other things. And so I just want to mention that because no one in this case was aware of that demand for speedy trial until this week. There's no one who indicates that they were aware of this. Why wasn't this a part of the motion to dismiss that was made months ago if the defense was aware of it? So I just mentioned that because we are now aware that there was the demand for speedy trial. I don't know if anybody was aware previous to last night when I discovered it, as far as the state is concerned. And so I mentioned that for the strength and the vigor with which the assertion is made. Now, I do not contest that the court has to weigh in some way the period of time since the demand, because the demand was weighed. But the issue for the court is how to weigh it. And I submit that it was not done. It was a very, very weak assertion of the right. However, as the court identified in speaking with Mr. Shart, the period of time leading up to that in which he absolutely could have filed a constitutional speedy trial demand is something that I think you should weigh against the defendant, because that is a number of years for which he had been charged with murder, which goes to his ultimate claim about the length of time. Now, I would like to move on to the fourth prong, which is the one about prejudice. And the whole reason that you go into the Barker versus Wingo factors is to see if seeing those 4 factors as a whole outweigh the presumption of prejudice that occurs from the length of time that gets you to those factors in the first place. There's been no showing of any demonstrable harm, and I'll explain both of those things. I showed my work in writing the state's response that I was able to file today, and I would just like to confirm what Mr. Shart said. He did not see the brief before today. I became involved yesterday when the trial team was unable to make the response in time for today's hearing. And so I showed my work in the procedural history of the case to describe all the periods of time in which the defendant has been in the Fulton County custody since his arrest on October 27th of 2015. That period of time that he was originally in the Fulton County Jail through that date to part of 2016, he was also in jail for other charges. And when he pled guilty to those other charges, as cited in the state's brief, to both booking numbers and to other case numbers that are within the court's records on Odyssey, every day of that was attributed to something that he got credit for time served for on the 10-3 prison sentence that he received for that other case. He left Fulton County's custody to prison, served out his sentence, and at that point he returned to Fulton County and bonded out the next day. So that one day in October 2018, the full day, so it's from the 23rd to the 24th, so it might technically be 2 days, but it seems like just one full day. That's the only day that I can identify that the defendant was in the Fulton County Jail for no other reason than the incident in which Donovan Thomas was murdered. There are intervening situations in which the defendant entered our prison under new charges and either resolved them or simply left the jail without them being resolved over the period of time that goes beyond that. And again, I've cited the Fulton County case numbers that apply to them, as well as the jail booking records that this court has access to through Odyssey. On March 17th, 2022, the defendant entered the jail once again. That's what he's currently been in there for. And that was for the separate additional murder of Shimel Drinks. And since that point in time, he has been in custody that entire time to this day on those charges, as well as any other charges that he may have. The relevance for which I bring this up is that number one, the court said that any pretrial incarceration is prejudicial under the prongs. That's not entirely accurate. It has to be oppressive pretrial delay incarceration. The courts have determined that simply being in jail does not set that apart from other circumstances. He has alleged issues about being stabbed in the jail this year, but there was no evidence that was presented to the court about that. I'm not personally well. ADA Sprinkle was not either. I'm not saying that it didn't happen. That's not something in the record currently before the court. What's important, however, is I've cited cases appellate courts, primarily the Georgia Supreme Court, which collects Salahuddin, Treadwell, Dagenbaugh, and I apologize to the court reporter for the spellings of every one of those names, as well as Cawthorn, where essentially, if you are in custody for something else, that cannot be oppressive pretrial incarceration for the purposes of Barker versus Wingo for this case. And other than that one day in October 2018, I'm not aware of any point in time in which Mr. Stidwell has been in the Fulton County Jail for no other reason than the murder of Donovan Thomas. And so I wanted to point that out for the court because he has not shown demonstrable prejudice in that regard. Now, the death of a witness is absolutely something that is a concern and something that comes up in constitutional speedy trial cases. However, in this particular case, the issue is it's essentially speculation as to what she would say otherwise. We have the fact that she said that her husband was a liar and that he was unreliable. We have that. It is literally recorded. And so, as the court noticed, we don't know at this point in time if the state's going to call that particular individual the relative of Mr. Stidwell. We don't know that we're actually going to call that specific individual when it comes time for trial. However, if we do, the defense has the statements in which she literally said those statements that they know of. They have a recording of that. And the state offers to stipulate that that will be admissible against, in Mr. Stidwell's case at least, for the purposes of dealing with the, I apologize, is it Jerron Stidwell? Tremaine Stidwell. I apologize, I got confused as to who I was speaking with. It's Theron Stidwell.
Your Honor, just for the record, I think I need to say this. We do not feel that the offer of stipulation is sufficient. For the reasons I stated earlier.
Okay, that's fine.
And so getting in that information is something that they would be able to do. It was my understanding from reading their brief that they were saying that they couldn't call her to impeach the relative.
If he's called.
Pardon?
If he's called.
If he's called, correct. And so that's why I cited case law that indicated that the potential prejudice from the death of a witness is alleviated when the state offers to stipulate to the information that they would have been able to get in otherwise. Going beyond the recorded statement that she has would be speculations why she acted that way. One of the reasons that Ms. Love had the cross-examination or the redirect examination that she had showing this evidence that she might not be the best witness for Mr. Stillwell because she might absolutely have been able to say that that did happen. She just didn't want to talk to the police about that. So one way or the other, it's speculating as to what she would say on the stand. What we do have is the statements in which she called her husband a liar, and those are recorded. And if I believe that they have been turned over in discovery, that is my understanding of it. And so that is something that exists in this case. The state submits that the court should, in weighing these factors, the appropriate outcome would be that this is not some issue in which his constitutional speedy trial rights have been violated in such a way that the court should grant a motion to dismiss. And the state is asking the court to deny the motion.
Thank you, sir.
Your Honor, may I respond just briefly? Very briefly.
Your viewpoint of brief is worrisome to me.
I mean it this time. I swear. Judge,
Two things. Again, we're speculating. That's my whole point. Speculation is bad. Live testimony, good. That's what the jury needs. That's what we're deprived of. Also, our assertion of constitutional speedy, Mr. Armstrong is calling it weak. I have never seen in any case law in my life some differentiation between a weak and a strong assertion. It's a piece of paper that says a very standard thing, which is we are asserting our constitutional right to a speedy trial. It's fairly boilerplate, and it was entered into Odyssey in this case, so I don't know of any service errors. It is true that things are more difficult for the defense to find because of our lack of access to Odyssey, which is a very uneven playing field, which I will be bringing a motion about later on. But that's just what I wanted to say. Thank you, Judge.
All right, you're very welcome.
Wait, I have something.
Uh-oh.
John, if you would just please take additional notice, the state brought it up, we didn't introduce anything about Mr. Stillwell having problems at the jail, and the court's well aware that he is in protective custody and isolation, and therefore that would be the reason for the prejudice.
Okay, all right. Okay, let me go ahead and just indicate that the state of Georgia filed a response to in opposition to the defendant's motion to dismiss. And Mr. Armstrong, in his procedural notes, I'm gonna mark that, Christine, as the next court exhibit in order. It'll be just for the simple fact that it gives it'll give some indication about what I considered. It has a really good procedural history of the case, which I will adopt in my order, giving the full of how we got from the arrest of Mr. Stillwell on or about the 27th of October of 2015 to our current posture in this particular case. So I will, without me kind of dropping it out on the record again. The next thing I will indicate is, of course, the constitutional framework for considering a speedy trial demand is found in the seminal cases of Barker versus Wingo, 407 U.S. 514, 1972, and Doggett, D-O-G-G-E-T-T versus United States, 505 U.S. 647, 1992. Those particular four-factor balancing tests. Well, the first part requires the court to determine if the time between the defendant's arrest or indictment and his trial was long enough to be considered to be presumptively prejudicial to the defendant. If presumptive prejudice threshold was crossed, the court proceeds to the second part of the framework, applying the content-focused four-factor balancing test to determine whether the defendant was denied the right to a speedy trial. Those factors the court must examine are: 1, the length of the delay; 2, the reasons for it; 3, the defendant's assertion of his right to speedy trial; and 4, prejudice to the defendant. And I'm required to look at those factors and the fact there are a number of cases that conclude Hurd versus the State, 295 Georgia, 559, pinpoint 562 to 563. It's just one of many cases that tells me what I'm supposed to apply that framework. Of course, as mentioned earlier, as to count 2, the defendant was arrested more than a year ago, so I'll apply the Barker-Doggett factors to that count. As to count 1, that count is, I agree with Mr. Anderson that we haven't addressed that particular issue, and that the same speedy trial demand, or the time does not apply to the predicate offenses in the RICO charge at this point in time. And Mr. Anderson cites State versus Messer, 207 Ohio, 5899, P18 Ohio Court of Appeals, 2007. So the speedy trial timetable in regards to the RICO charge begins to run upon the date of the defendant's arrest for the RICO charge itself, not upon the dates of the arrest for the predicate acts upon which the RICO charge was based. So in terms of count one, it fails. So I agree with the state on that particular issue. Now, as mentioned earlier, this case took a little bit of time to get acts. A homicide, a purported homicide is cites Schleiler, it's SECHLER versus the state, 316 Georgia Appeals 675, 2012 case for the proposition that Mr. Anderson cited for, that case involved 12 defendants, continuing enterprise, 20 predicate acts, and it justifies the length of the time. In this particular case, we have much more defendants as well as predicate acts, and it took a little bit of time for this to get together. So, in terms of the state's ability to prosecute the case, so much longer length of time justification in this case due to the complexity and the work. I'm going to weigh that against the state benignly. As for the second factor, cause of the delay, there was no deliberate attempt to delay the trial in order to hamper the defense. It just took a little bit of time because this was a very unusually complex case. And in terms of the division of from October the 27th, 2015 through the present time, the court will adopt Mr. Anderson's review of the particularized investigation and the reasons for the delay. And I'm not going to weigh this time against either party. Now, as for the assertion of his right, Mr. Shart does reference that he could not have filed a statutory demand during that particular point in time, and that the constitutional speedy doesn't apply. I agree with Mr. Anderson. In fact, a constitutional speedy trial demand, you can apply ones from the time of arrest. You can, if you want, you choose to do so. Also, taking judicial notice of the order from the Supreme Court of Georgia, as well as from the Honorable Christopher S. Brasher, former Chief Judge of our court, that you, Mr. Shart, you could have asserted a right. The question is whether or not it would have, those two orders from the Supreme Court as well as from our court basically told those particular speedy trial demands, those people who filed them during this particular period of time, and would have made them come alive again on the 2nd of January of 2023. So I do have to weigh that against your client, since he did not assert his right up until the time periods that you indicated earlier to the court, those being July the 2nd of 19, May 9th of 22, and 5 August of 22. In terms of whether or not the defendant's been prejudiced, the defendant alleges two bases for prejudice. One is oppressive pretrial incarceration, and the second one being harm to his defense due to the death of a witness, that being Vanetta Guffey. In terms of pretrial incarceration, Mr. Mr. Stillwell is not served a day of incarceration based solely on the murder of Donovan Thomas. He's been, and outside that one day, I agree with the state that he's been incarcerated for other offenses on top of the alleged murder of Donovan Thomas. And I'm going to reject his claim that he suffered oppressive pretrial incarceration from this prosecution. In terms of the death of the witness, Miss Vanetta Guffey, the state is in concurrent. I mean, the court is in concurrence with the state in terms of the speculative nature at this point in time of the calling of Miss Guffey to refute anything from what is Mr. Stillwell, not the defense, Shannon Stillwell, but Theron. Thank you very much. Theron Stillwell, if he were called to testify, and the state has offered in this particular matter to stipulate to that particular test, and even though that particular issue, should there be a need to do so, and I know, Mr. Sharp, you have mentioned that, of course, live witness would be a better witness, but unfortunately, she has been called home, and that's not going to be a possibility in this particular situation. But right now, it's speculative in nature. So, for the above aforementioned reasons, I'm going to deny the defendant Shannon Stillwell's amended motion to dismiss and amended motion to dismiss the indictment on constitutional speedy trial grounds. Mr. Anderson, if you would prepare a suitable order memorializing the court's resuscitation, send that to Mr. Sharp for his review and comment, and if you could get it filed sometime in a most expeditious manner, that would be greatly appreciated.
Yes, Your Honor.
Okay.
Your Honor, the state decided to call Mr. Stillwell, and just for the record, I've been saying
Theron Stillwell.
It's Termon.
Termon Stillwell. Okay.
And Your Honor, if the state should elect to call him, maybe revisit this issue because it will no longer be speculative.
Well, it would be an evidentiary issue at that point in time. So, of course, it would be subject to a proper evidence objection at that point. Okay? All right. Folks, we've kind of come to the end of the day. Let me go ahead and just review Ms. Rosenwasser and for all of the lawyers in this particular case. I know we were supposed to call Mr. Hall today. We're not going to get to him given the hour being 5 of 5 on today. So if we could potentially have him as one of the individuals we could call. I was going to ask Ms. Rosenwasser, is it possible for you to basically, for maybe us to move through the 5 witnesses that you have in terms of length and then call Mr. Hall, and then we could kind of bleed him over into the 22nd if necessary?
I'm not sure his schedule. I believe he's still waiting for us today, so I believe his hours are usually 7 to 3, so we had been planning to ask if he could probably start it off. Well, I'm not sure if it's available on the 22nd or something.
Now, tomorrow.
But bleeding to the time.
Well, why don't you ask him? I mean, look, he's a witness that's, I'm sure, is familiar with this kind of, I mean, our issues involving calling witnesses.
He's advised that we could put him on call for tomorrow afternoon.
That would be great. If he could potentially be ready to be on call between 12 and 1, would that work? Appreciate it. Thank you, Officer Hall. I really appreciate that. We just had a long day, okay? All right. Thank you, sir.
Your Honor, there's 4 others than him. The other person who's listed yesterday, listed for tomorrow, we actually called her yesterday.
You have John Paulsnick.
Yes.
You have Dr. Henninger. Oral.
Yes, we can get them all.
Okay, if you'll call them before we deal with Officer Quentin Hall, that would be great.
We can do that, Your Honor.
Okay, all right. Well, that's our order of march for tomorrow. Any other administrative announcements you need to make on behalf of the state?
I don't believe so, Your Honor.
Okay, all right. Defendants, any defense attorneys, anybody? All right, we'll see you all in the morning, 9 o'clock for an anticipated 9:30 start time.
Everybody stay seated.